For the fifth applicant, Mr. Casper appears for the applicant. However, Mr. Gaib is standing in. For the sixth applicant, Ms. Gebhardt, and Mr. Gaib is standing in for Ms. Gebhardt. And the matter is before this court for judgment, and we are ready to receive the judgment. Mr. Court, pleases.
The court pleases, Your Worship, I confirm appearance for applicant 1 and 2, as well as standing in for Mr. Casper and Ms. Gebhardt, who are unavailable but extend their apologies to the court. We are ready to note judgment, Your Worship.
May it please the court, I am Mr. Laya, representing the third and fourth applicant in this matter. We are ready to note judgment.
Yes, the court will proceed and read the judgment into the record the next about 2 hours. Introduction. Section 60 in brackets 1 of the Criminal Procedure Act 51 of 1977 in brackets Act 51 of 1977 as amended states that any accused who is in custody in respect of any offense may at his or her first appearance in a lower court or at any stage after such appearance apply to such court to be released on bail in respect of such offense, and any such court may release the accused on bail in respect such offense on condition that the accused deposits with the clerk of court as the case may be, or in the official or with the official in charge of the correctional facility where the accused is in custody, or with the official in charge of the correctional facility where the accused is in custody, or with any police official at the police station the accused is in custody. The sum of money determined by the court in question. Therefore, an accused who is in custody has the right to apply for bail, but this falls short of entitlement to bail. Bail can therefore not be claimed as of right. Hence the need for its application and to establish that the applicant is a candidate worthy of being granted bail. Serving before this court are opposed applications for bail. The applicants are charged of numerous counts, among others fraud, theft, alternatively theft under false pretenses, money laundering in contravention of the Prevention of Organized Crime Act 29 of 2004, in brackets poker, conspiracies, corruptly accepting gratification or giving gratification to an agent, dealing, using, holding, receiving and concealing, as well as corruptly using office or position for gratification in contravention of sections of the Anti-Corruption Act 8 of 2003. For the full charges, see the charge sheet. The applicants appear in the case that has become known as Fuel Road. Mr. Namanje, assisted by Mr. Gaib and Mr. Kadondana, appeared on behalf of the first, second, and third applicants, as well as accused 10. Mr. Bangamwabwa appeared on behalf of the fourth and fifth applicants. Mr. Casper and Mrs. Gebhardt appeared on behalf of the sixth and seventh applicants, respectively. The respondents, in bracket the state, is represented by Advocate Lulungwe, herein after referred to as Mr. Lulungwe. The applicants will be referred to as first to seventh applicants individually or collectively as the applicants for purposes of these proceedings. The first to fifth applicants brought their bail applications viva voce, whereas the sixth and seventh applicants brought their applications by way of affidavit. Mr. Obeti Inambao will be referred to as the investigating officer for purposes of these proceedings. Further, Enecon Pty Ltd and the Ministry of Defense will be referred to as Enecon and MOD respectively. The National Petroleum Corporation of Namibia as Namcor, whereas Namcor Petroleum Trading and Distribution Pty Limited will be referred to as Namcor Trading. Enecon and Namcor Trading will be referred to as such individually or collectively as the parties. The Anti-Corruption Commission and the Anti-Corruption Act number 8 of 2003 as the ACC and ACC Act respectively. Further, Enecon bank account number 800-35-10848 and number 8023-531520 will be referred to as bank accounts number 848 and number 520 respectively. The following factors are common cause and not in dispute. Both applicants are Namibian citizens. The first and second applicants are brothers, business partners, and directors of Enecon. The third applicant is the wife of the second applicant, and she was already granted bail with conditions. As such, this court will not deal with her evidence for purposes of these proceedings. The parties entered into an asset purchase agreement in brackets APA. The first and second applicants signed the APA on 15 July 2022 as directors of Enecon. And the fourth applicant signed on 18 July 2022 representing Namcor Trading. Namcor Trading paid 53,212,000 Namibian dollars, or in short 53.2 million in two parts, 35 million and 18.2 million on 18 July 2022. To Enecon, 35 million was paid back, 35 million was paid to Enecon bank account number 520, and subsequently it was paid back to Namcor Trading in terms of the agreement in partial fulfillment of Enecon's debt. 18.2 million was paid to Enecon bank account number 848, and subsequently 3,613,000 and 9.5 million of that amount was paid to Onyeka CC and Eco Trading, respectively on the even date. Further subsequent payments were made from Eco Trading CC to various business entities and accused two in particular. The following amounts were paid: 1 million to Venus Trading, 1,470,000 Namibian dollars to Quality Meat CC on the even date. In turn, Quality Meat CC made several payments to other persons and business entities, including 960,000 Namibian dollars to accused two personal Standard Bank account number and 500,000 Namibian dollars to Panduleni CC, which is owned by accused 8, the husband of the fifth applicant. Onyeka CC paid the first and second applicants 1.5 million Namibian dollars each on the even date. Venus CC paid the sixth applicant 10,000 Namibian dollars on 4 August 2022. The the fourth applicant was the managing director in brackets MD of both Namcor and Namcor Trading at the time. The fifth applicant had signatory rights to Enecon bank account number 520. Further, the fifth applicant and the eighth accused are married to each other, and the former has signatory rights to Panduleni CC as well. The fifth applicant was employed by Namcor as the executive for finance and administration, whereas the sixth applicant and accused 8 were employed by Namcor Trading at the time. Accused 8 withdrew his bail application. I must indicate from the onset that underlined in this judgment is my emphasis. Summary of the evidence. The first applicant testified that he's a Namibian born in Oshikoto region. He resides at number 1500 R595 Hammerskopweg, Hockland Park, Windhoek. The court asked him, did he say number 15? He testified no. 1500. It is not an elf, but the outside number. Mr. Namanje stated that the same property where he lives, the street number is 15, but the F in bracket F number is 595. He confirmed same. Exhibit 8 contains his personal information and reflects his residence as number 15, Hammerskralweg, Hockland Park, Windhoek. He is a freedom fighter and a lawyer by profession. He was arrested on 9 July 2025. He was informed that the state was looking for him, and he went to Council of Record. They drove to ACC and he was arrested. He did not run away, and he was aware about the investigation since 2020. Excuse me, since 2022. He cannot run away because he has business interests, a house, and employees. He's not afraid of the case because it is a commercial transaction. He wants to clear his name and will go nowhere. He is self-employed, operating a number of businesses, married with 4 children. He has an ordinary passport and it is with his Council of Record. He does not have a problem if the same is provided to the respondent. He owns properties with a total value of 118.2 million Namibian dollars. His liabilities are 27.3 million with a net asset of 90.9 million. With regard to the charges, the first applicant testified as follows. Count 34 relates to Enecon and not him personally. He was a shareholder and director of Enecon. First, there was a discussion or engagement between him as chairperson of Enecon and accused number 1, in bracket the 4th applicant, subject to Namcor Trading approval, and he does, in brackets, did not check for internal compliance by Namcor. In terms of page 63 of his index bundle, an offer was made by Namcor Trading to him dated 18 July 2022, subject to management approval. The Namcor went to Enecon's home-built service stations in the military bases, and he did not know they were separate entities. The offer was to buy storage facilities designated at MOD for 53.2 million. The service stations are home-based because Enecon built them in the military bases with its own resources. They built the tanks and pumps in those service stations. It was found that all service stations in the military were not compliant with the Ministry of Mines and Energy. As such, they built new ones with Enecon resources. The old service stations were left there to be decommissioned. To recoup their investment, they were given a 15 years contract to provide fuel to MOD. The agreement with MOD is at pages 83 and to 92 of the said bundle. The fuel management technology was different and not the one that was sold to Namcor, but the right to use the pumps and tanks in MOD. Enecon changed its name from PDF. The agreement of 19 September 2012 was amended on 20 August 2013 to include construction of new home-based service stations with military consultation, subject to Enecon, then PDF, getting financial assistance in 9 military bases: Windhoek, Osona, Gobabis, Keetmanshoop, Walvis Bay, Oshivelo, Grootfontein, Rundu, and Oluno. The estimated cost was 43 million, but it went to 58 million. They obtained funding and constructed the service station, including pumps, tanks, canopies, petrol attendants' houses. Enecon used its own resources to build the asset. They negotiated for 53 million. Namcor offered to buy their interest, and that is not a crime. In terms of their agreement with the military, there was no specific amount they were required to recoup. They could even get 60 million. Further, he testified that Enecon had about 2 to 3 accounts, and they would give them, in bracket, Ministry of Finance, instructions with correspondency for them to deposit in that particular account. Officials or Ministry of Finance would have made wrong or by mistake payments into their accounts. Further, the first applicant testified that until Namcor offered, and it was their responsibility to fix the pumps and environmental issues. Namcor offered, evaluated, and drafted the APA. He and the second applicant signed same on 15 July 2022, and the fourth applicant signed on behalf of Namcor on 18 July 2022. They did not sell the system, the fuel management technology, but the right to use the pumps and tanks in MOD. They wanted to work on the old fuel service stations, but feared that if they opened and there were environmental issues, then they decided to construct new service stations with the ministry's consultations. It is apparent that the parties are Enecon and Namcor Trading. As such, reference to Namcor means Namcor Trading unless otherwise stated. Further, he testified that the fourth applicant did not accuse him of fraud. The assets were built with Enecon's resources, so no one will accuse him of wrongdoing. He did not misrepresent to Namcor. Namcor went and verified that those service stations exist and then consciously took a decision to offer and buy the assets from Enecon. He does not understand how he misrepresented. It was up to his company, and he had the right to sell those rights. Since he was conscious and truthful that the assets were built with Enecon's resources, only his company would have entered into the agreement. Paragraph 1.1 of the agreement deals with the rights, title, and interest, and they sold the rights, title, and interest. And this was different from the fuel management system. The assets refers to home-based service stations or fuel stations, he testified. they sold the rights, title, and interest in and to the assets. In the oil industry, the company that built those assets remained the title holder. Enecon built the pumps, tanks, and all underground connections, as well as petrol attendants' houses, and they remained owner until 2031. Further, the first applicant testified that the purchase price was 53.2 million. The bank account name was Enecon Bank Windhoek, account number 520. Accused 3 in bracket, the fifth applicant, Namcor's finance executive, was a primary signatory for transparency. On count 35, he testified that he is charged in terms of section 35 in brackets A and B. The respondent did not choose either of them. He denied giving out an amount of 2.5 million as inducement or reward as per the allegations. Enecon did not pay 2.5 million, neither did he induce or reward anyone. The same explanation was given for count 36, that the respondent did not choose either section 35, subsection 3 in brackets A or B. Count 37 states offenses such as fraud, theft under false pretenses, and money laundering, which offenses do not fall under Chapter 4 of the ACC Act. He did not attempt and did not succeed, nor did he conspire with anyone. Count 39 does not talk about disguising the nature or origin of property. Count 40 was directed at him personally, but he was never personally in contract with Namcor Trading. The contract was with Enecon and he was a director. He was never told that he was charged on behalf of the company in terms of section 332 subsection 5 of the CPA. Further, the first applicant testified that it was correct that the agreement was between Enecon and Namcor Trading. The money from MOD meant for Enecon was to be paid to Namcor in bank account number 520, where the fifth applicant was co-signatory. He proceeded to testify that count 40, subsection A and B was correct. In other words, both count 40, A and B were correct. Deposits were made in the said bank account. The difficulty is that if he was provided with the information about invoices, he would have explained. Further, he testified that officials made payments or wrongfully paid into any other accounts. They had other bank accounts, and staff could provide other accounts other than the correct one. There is no dispute. There was an agreement before as per count 40, and that is correct. He did not commit fraud, and the agreement was between Enecon and Namcor. Further, the fifth applicant testified that count 41 deals with section 4 in brackets B in brackets Roman 1 and Roman 2 of POCA. The amount of 213,000 was paid into Nyambali Medical Center CC in brackets Nyambali CC. He does not know the unlawful activity involved, and he was never informed such amount is part of unlawful activity. Count 42 relates to 1.5 million from Onyeka CC and falls under POCA. Onyeka CC is owned by the second and third applicants, and he was just a signatory to the bank account. It was correct that Namcor Trading procured assets for storage facilities. It was a commercial consumption in brackets transaction, he could not remember why the amount of 3.6 million was paid to Onyeka Sisi due to passage of time. He was a director of Enecon until 21 February 2023, about 8 to 9 months after the APA was signed. Further, the first applicant testified that we, in bracket they, used to get fuel from Total Energy, but they had volume issues and thus entered into an agreement with EcoFuel CC. EcoFuel CC and Eco Trading CC are two different entities, both owned by Victor Malema, in bracket Malema. He confirmed that 35 million was paid into Enecon account number 520 on 19 July 2022, and the same amount was paid back to Namcor Trading as agreed in account number 8000158325. 18.2 million was paid into Enecon's bank account number 848 in terms of the APA. Further, the first applicant testified that he was never told about the 480 million. 53 million and 70 million is not 480 million. It was wrong for the state to accuse him of 480 million. With regard to the grounds of objections, he testified further that there is no way he can run away and he wants to clear his name. He has properties, people to take care of, as well as employees. He was aware about the investigations and he could have ran away. He will comply with a warning or bail with conditions and come back to the court. He will not interfere with anyone. He has 26 employees in the various business entities. The state does not have a strong case. It was a commercial transaction and he can afford bail in the amount of 20,000 Namibian dollars and will reside at F 595 Hawkland Park, Windhoek. The second applicant testified that he was born in Omuntele, Oshikoto region. He has 5 children in total and 2 wives. He was arrested on 9 July 2025 at home. He received a call from his tenant in Pioneers Park that the police were looking for him. 2 hours later, more than 15 police and ACC officers came between 9:30 and 10 a.m. The third applicant went to greet them and they said they wanted to talk to both of them. The children were sleeping. The officers came and they went to sit in the sitting room. The police informed them that they were under arrest. They asked them to dress up properly and they were escorted individually to dress up. Theirs, in bracket, his right to remain silent, was explained in offenses section 35, but not in detail. The police did not say the reason why they were arrested. He even asked them to wait for his lawyer, but they said there was no time to wait. He was charged on 10 July 2025, and the police just repeated the sections and asked him to comment. He asked them, on what? With regard to the grounds of objection, he testified that he will not run away. He has his dignity, his family, and properties. He has nowhere to run away. He never committed any offense for 52 years. He arrived on 7 July 2025 from the north, and he was 60 kilometers from Angola. If he wanted, he could not come back to Windhoek. He has no fear and he wants to clear his name. He has a passport and it is with his counsel of record. He has no issue with bail with conditions and hand his police. He will not interfere with investigations. He will stand his trial and both his parents are deceased. Further, the second applicant testified that he has a house in the north in Onipa, Oshikoto region and 4 siblings. He has a diploma in business administration from International University of Management in brackets IUM and a certificate in business management from Stellenbosch University. He has total assets valued at 113 million Namibian dollars and the liabilities of 28.2 million dollars with net assets valued at 84.7 million. The timing of the arrest was wrong because he was on the verge of signing an agreement with an investor for an EPL worth 1 million US dollars, about 18 million Namibian dollars. Onyeka Clearing, Forwarding and Logistics CC, in brackets Onyeka CC, was established in 2004 and he was a first subscriber of the CC. The third applicant became a 50% partner, but presently he has 100% membership. He was in pain because the third applicant was arrested because she is just a member and he was running or managing it. With regard to the charges, the second applicant testified as follows. Count 55, he was a director of Enecon and at the time and he never conspired. It was correct. The said amount of 3.8 million was received for clearing, forwarding and storage for fuel management technology. He was involved in both Onyeka CC and Enecon. He appeared in court on 8 July 2025 and the charges, in brackets amount, is not 480 million. It was incorrect that they embezzled 480 million. If he was given the opportunity by the ACC to explain, he could have done so. His continued incarceration will affect his entities. He has 26 employees and earns about 200,000 Namibian dollars. He is facing 10 charges from counts 43 to 53. On count 53, he testified that he sold rights, titles, and interest to Namcor for 53 million. Not him personally, but Enecon. It is not correct that he sold, and he did not commit any fraud. Namcor offered and determined the amount, and he was not involved. He was not involved in any crime. On count 44, he did not do that. He did not know that accused 8 and 3, in brackets, fifth applicant abused their office and the ACC did not tell him about the allegations. He did not offer accused 2 and the fifth applicant 2.5 million. However, he knew accused 2 and fifth applicants at the time when Enecon signed the agreement, and he had no other relationship with them. On count 45, he personally never sold to Namcor but Enecon, but no crime was committed. He only saw the allegations when he was charged. Further, the second applicant testified on count 46 that 53 million was received by Namcor, by Enecon, not him, and that was in terms of the APA with Namcor. It was not proceeds of fraud, but business transaction. Enecon paid for the assets built in MOD. Count 47 does not say who is the representative of EcoFuel. The number is not given. He did not conspire, and he does not even know quality meat. Count 48 has different dates, and he never received the same amount in 2021 and 2022. On count 49, he does not know the dates and invoices, and Enecon received money from MOD in the mentioned account, and there are contradictions on the dates. On count 50, he knows the amount of 213,000 paid by Onyeka Sisi to Nyambali Sisi during COVID-19 for masks. It was not proceeds of unlawful activity, and he was a member of both Onyeka Sisi and Nyambali Sisi. Further, the second applicant testified that on count 51, the unlawful activity was not identified, and he cannot be a shareholder of Onyeka Sisi, but a member. The bank account mentioned on count 52 was not his. There is an alternative to count 53, but no count 53 itself. Section 6 in brackets 1 in brackets Roman 1 and Roman 2 does not exist in poker. He was a director of Enecon, signed the APA to sell rights, title, and interest to Namcor. Assets refers to tanks, pumps, houses for petrol attendants, and canopies. He had nothing to do with the share valuation. Ducatus was the internal auditor that prepared the asset register as required per the agreement for its ownership of the assets. Pumps, tanks, and canopies are not movable assets. Are movable assets. The petrol attendant's house was prefabricated structure and can be moved. They were built by Enecon with its own money and had rights, title, and interest for 15 years. There was no prohibition to transfer rights, title, and interest. MOD had no issue with the incumbent assets, and there was no clause that they cannot transfer rights, title, and interest. The parties were MOD and Enecon, and a third party cannot impose terms. He also confirmed that he signed as a witness on the APA, and he was never aware of the terms of the agreement. The verification clause does not prohibit sale of assets. There was a cession agreement as EcoFuel CC had an outstanding debt with Namcor for 70 million. Enecon took over the debt of EcoFuel CC. The second applicant testified further that why claim 53 million if 35 million of that amount was paid back to Namcor. He reasoned that 35 million was considered legitimate, whereas 18 million was illegitimate. With regard to the grounds of objections, the second applicant testified that he cooperated with the police and he did not run away or attempt to do so. He had no intention to run away. He will comply with bail conditions. If summoned, he will come back to court. The amount of 480 million was just to strengthen the state case, and it was not true. He can afford bail of 20,000 Namibian dollars. Corruption was serious in nature, and the public needs to know, but the truth and facts from the newspaper are not correct. They were only supposed to be charged for 18 million, not 53 million, because 35 million was paid back to Namcor. Wrong information fueled public perception, he testified. The fourth applicant testified that he resides at number 2 Hansberg Street in Windhoek, his property, but he does not have a title deed himself. He was born in Omuntele village, Oshikoto region, but he grew up in Windhoek. He holds a Bachelor of Science in Chemistry and Biology, as well as an MBA from the University of Stellenbosch. He is divorced with 10 children, of which 8 are minors. He was the managing director in brackets MD of Namcor from 2015 until he was dismissed in 2024. Further, he testified on count 1 that it relates to corruptly using position for gratification. The parties are Namcor Trading and Enecon, a private company, not a public company, and it does not get money from Namcor, in brackets the holding company, and has its own 3 board of directors. It is not correct that the company was a public body. He did not sign the APA as MD of Namcor, but of the subsidiary Namcor Trading. He was MD of both Namcor and its subsidiaries. The offer and APA have to be read in context of the FSA. The parties to the agreement are Namcor Trading and Enecon, a seller and buyer respectively. This was about the fuel supply between the parties and the buyer to buy exclusively from the seller. It was signed on 16 March 2022. The offer and the APA emanates from clause 4.2 of the FSA. That is the fuel supply agreement. It was factually incorrect that Enecon sold Dreams to Namcor Trading. In compliance with the above clause, Namcor Trading team went to inspect and verify at the various military bases. In addition to Namcor Trading's own evaluation, they also contracted a consulting engineer for an external evaluation. Accused 4, in brackets 6 applicant, wrote an internal letter to him and he approved same. The 6th applicant was employed by Namcor Trading and not Namcor, the holding company. They are employees of Namcor Trading, in brackets the subsidiary, and those of Namcor, the holding company, he testified. Mr. Hashela did the project feasibility study. The APA was signed by Enecon and Namcor Trading on 15 and 18 July 2022, respectively. The effective date was 18 July 2022, and that was in terms of clause 1.3, page 54 of Exhibit E2, which states that the effective date shall be the date on which the last party signs the agreement. Further, the 4th applicant testified that the APA does not make reference to criminal prosecution. He signed same in his capacity as MD of Namcor Trading for the benefit of both parties. Namcor Trading was to acquire assets and supply fuel to Enecon. He was not expecting a personal benefit. No one wants to be an MD of a public institution if he knows that criminal prosecution may follow. With reference to count 2, he testified that it does not make sense. He signed on behalf of Namcor Trading and he could not pretend to Namcor. They did not buy 9 service stations. They bought bulk fuel storage facilities or storage assets from Enecon. The assets were not owned by MOD, but Enecon. If he knew, he could not have signed the agreement. On count 3, he testified that in all those business transactions, he was not acting as an agent of Namcor, but Namcor Trading. Further, the fourth applicant testified that he knows Malema. However, he does not own and possess such a vehicle. Malema was not a director of Enecon during the negotiation. Count 4 was factually incorrect because he did not receive any ratification for himself and the agreement was to the benefit of both parties. He did not gratify anyone and all he did was to sign Sam as MD of Namcor Trading, and neither did he give any reward to any person. Count 5 does not make sense. On count 6, he did not agree with Malema. Count 6, he had no agreement with Malema. On count 7, he did not pretend that he had authority. If he exceeds his authority, the board has the right to discipline him. Further, he testified that the schedule of authority at page 259 of Exhibit E2 is for Namcor, but it also relates to Namcor Trading. Namcor Trading was, in bracket, is a subsidiary of Namcor. And page 256 of Exhibit E2 states that Namcor and its subsidiaries. The MD of all companies sign and there is no limit. It does not mention the board of directors. He testified. Further, the fourth applicant testified that he was arrested on 8 July 2025 at his residence around 8:30 to 9:45. He had a meeting with someone and the investigating officer called him that he was outside. He informed him to wait. He met the investigating officer outside his garage. The police referred him to several clauses of the ACC Act that he allegedly violated, telling him what he did. He was just informed 2 days later while at CI's police station. The investigating officer attempted to explain the charges, but not in detail. He asked him, what are the charges he was specifically facing, and the investigating officer mentioned some of the charges. Not in detail, but he attempted to explain, and the media was outside. He was aware about the ACC investigations through sources, and that a police docket was registered. The fourth applicant testified further he will not run away, and if he wanted, he could have run away long time ago. He had no ties outside Namibia. His roots are here. He wants to face the charges and clear his name. The charges will not stand during the trial, and he was ready to stand trial. He does not believe that the charges are strong. He has a passport and it was at home. He was willing to surrender Sam to the investigating officer. He was currently unemployed and survives on his last pension, and he can afford bail of 10,000 Namibian dollars. With regard to public interest, he testified that when he started working at Namcor, he had a lot of enemies and people were coming after him. There is no evidence against him, but his sin was just to work for Namcor. He does not understand why it is not in the public interest for him to be granted bail when the case was not that strong as the media portrays it. He has no interest in investigations and will not interfere with Sam. He will comply and abide with bail conditions. Further, the fourth applicant testified that the APA was prepared by Namcor Legal Department for Namcor Trading, and they purchased rights, title, and interest into those assets. He does not know about the 9 service stations. The 2 entities have 1 legal department. Part 1 of clause 1.1 of the APA was compiled by Enecon, and he could see the asset register, and that was the proof before they could proceed. Page 79 of Exhibit E2 contains Enecon's asset register, and that is the document about the ownership of the assets. Authored by Ducatus, confirming the correctness of the asset register. Pages 80 to 85 contains the assets. He testified that it was not in dispute that Namcor paid 53 million in total. They could not physically take possession of the assets because they are in the army bases. In terms of clause 1.3 of the agreement, asset transfer shall be effected on 18 July 2022. From that date, they remained assets of Namcor. The agreement persisted until such time that it was cancelled, whereafter he left Namcor. Whether Namcor utilized them, in brackets, the assets or not, is another issue. Pages 86 to 88 of Exhibit E2 contains a letter from Enecon proposing to cancel the APA and refund Namcor 53 million. Dated 17 July 2023. On 5 October 2023, Namcor accepted cancellation and refund. Subsequently, Namcor accepted cancellation but insisted to have the agreement remain in force. The fifth applicant testified that she was born in Kawoma in Zambia to Namibian citizens during the liberation struggle. She came back in Namibia in 1989. She resides at 49 Heckle Street, Dorado Park, Windhoek. Her property co-owned with accused ate her husband. They have 3 children together, and they were left in the hands of a nanny. They called a relative from the north to assist in taking the children to school. She is employed at Namibia Qualifications Authority, in brackets NQA, as head of finance and administration. She was arrested on 8 July 2025 at work. Around 11 hours by 2 female arresting officers and 1 ACC officer. She was in a management meeting and received a call that accused 2 was arrested, and she called the 4th applicant to confirm, but he had no knowledge at the time. The 4th applicant later called her and confirmed that it was true accused 2 was arrested. Accused 8 called her that he heard that there were warrants of arrest for Namcor employees and she might be one of them. Further, she called and informed her supervisor if she can go home because she did not want to be arrested in the office. As she was talking to her, the secretary came and informed her that the police were looking for her. She then went with her supervisor to the parking to meet them. The police introduced themselves, Inspector Anna and her colleague and the ACC officer. Inspector Anna informed her that she was under arrest for corruption, fraud, and money laundering on matters related to Namcor. She showed her a warrant of arrest with sections of the ACC Act. She also explained her right to remain silent and that whatever she said may be used against her. The officers were driving 2 vehicles, a sedan and a double cab. She did not evade. In fact, she went to the police. All that Inspector Anna said is that she was under arrest in terms of Section 35 of the ACC for corruption, fraud, money laundering on matters related to Namcor. She was only informed in details on 9 July 2025 when Inspector Anna and ACC officers went to Windhoek Police Station. The ACC explained in detail. When she was arrested, she was asked if she knew where her husband, in brackets, accused 8 was, and informed if she can take the police there so that he can take her phone and handbag. She then took the police to his workplace. Further, she was asked who was with the children, and she responded they were at home since it was holiday. They arrived, but he was not at work, and she was asked to call him. The other officer asked her who was going to take care of the children in the long run. It then dawned on her that accused 8 might be in trouble, and she also saw his name on the paper. Accused 2 came, and he was arrested. The double cab was meant for him. Her handbag was given to her brother, who was with accused 8. The police kept her phone, and she was only allowed to call accused 8. They drove to the ACC and sat in the boardroom. Pictures were taken of her to confirm ACC arrest. She was also asked to give her phone and password to Inspector Anna, but she could not remember it, as she uses face recognition. She attempted 5 times, and lastly, the password worked. She was also asked to switch the phone on and off using the PIN and password to prove that the PIN number was correct. Accused 8 intervened and said they needed a search warrant, and he was told that the phones are now ACC properties. Accused 8's watch was also removed. When accused 8 tried to intervene, Inspector Anna told him that he was urinating on her, and as a result, they gave the phones to her. She was told that she will be taken to Windhoek police station. On the way to Windhoek station, the second officer requested to stop at Windhoek station because they wanted to see number 1 in person, for they had not seen him in person. She asked, who is number 1? But they did not respond. She asked again. The second officer nodded to confirm that number 1 was the 4th applicant. The 2 officers left her with the ACC driver, who asked them whether it was correct to leave a suspect in the vehicle, and they responded that the vehicle had child lock. Thereafter, they proceeded to Windhoek station. Upon arrival, Inspector Anna told her, "Welcome home," and she responded that that was not her home. She was handed over to officers at the station. She has assets as depicted in Exhibit E2 with a total value of $4,250,000. She also runs a tuck shop business employing 2 female persons on a permanent basis, and it generates 18 to 20,000 Namibian dollars per month. But at the moment it was closed because she was in custody. Her ties are in Namibia, and her parents are pensioners. Her passport with her council of record, and she has no objection if same is provided to court. Her employment contract with Namcor is on page 30 of Exhibit E2 as Executive of Finance and Administration, responsible for financial management of both the holding company Namcor and its 2 subsidiaries, Namcor Exploration and Production Pty Limited and Namcor Trading and Distribution Pty Limited in brackets Namcor Trading. Further, the fifth applicant testified that she was not involved in the APA. She confirmed that she was a signatory to account number 520, opened in October 2021 by the directors of Enecon. The effective date for her to be a signatory was 16 March 2022, when the FSA was signed to protect the interest of Namcor. When Enecon entered into the FSA, one of the conditions was that if money comes from MOD for the supply of petroleum products purchased from Namcor, Enecon should pay the money to Namcor to ensure that funds are not used for any other purpose. The control measure was that a signatory from Namcor be put on that account. Immediately when Enecon transferred money into that account, it was immediately paid to Namcor, and Exhibit B1 reflects such payments. She testified that starting from 6 July 2022 to 21 October 2022, she counted on her own in total 10,224,198 Namibian dollars 81 cents paid to Namcor. She has demonstrated that every time the account was credited, the money was debited to Namcor. The only transaction was 35 million, but she has demonstrated 10.2 million paid to Namcor. Namcor was paid and evidence is before court. The statement that they were giving fuel for free was false and misleading. Enecon paid, and that means that Enecon account number 520 for was received money, for Namcor Trading received money. The money was coming from Enecon's main account number 848. If the money was paid into into account number 848 by Ministry of Finance, it was then paid to account number 520. The purpose of Enecon resolution dated 26 October 2021 is that Enecon board resolved that she can be added as a signatory. On Namcor's side, the effective date was 16 March 2022, and she could not transact before that date. And she had no authority. The APA was a product of the 16 March 2022 agreement to protect Namcor's interests. She had no access to account number 848. 4.9 million was paid into account number 520 on 20 January 2022, and at that time she was not a signatory to the said account. Further, the fifth applicant testified that she was a Namcor employee and taking care of the subsidiaries. With regard to financial matters, there is a financial statement for Namcor and another for Namcor Trading. Payments to account number 520 goes to Namcor Trading, she testified. Namcor receives levies from National Energy Fund in brackets NEF, and that is allocated to Namcor for administrative and payment of expenditures. Namcor Trading receives no money from the levy given to Namcor. Namcor Trading operates independently, generates its own income predominantly from the sale of petroleum products, and pays its own expenditure and debt. Namcor administratively supports Namcor Trading, she testified. The finance function is in Namcor. However, there are teams supporting Namcor trading. Her evidence was that Namcor accountant is allocated to Namcor trading, paid for by Namcor, the holding company. With regard to charges, the fifth applicant testified as follows. On count 20, she does not conclude, sign or negotiate FSA with resellers or sit in such meeting. She was not part, she is, in bracket, was part of the credit committee that authorizes credit policy. Clause 5.9 of the credit policy gives her authority to give credit to customers. Clause 6 deals with the composition of the credit agreement. Clause 6 deals with the composition of the credit committee. Each customer has a credit limit and it can be 5 million, 50 million, or 100 million. Customers can request credit above 15 million. Clause 8 allows credit above 15 million. In terms of clause 5.8, the practice was that customers have 30 days to pay. That is why they allowed customers to exceed the limit. Herself, the executive of downstream supply and logistics, in brackets accused 2, and the fourth applicant will take all credit decisions. The composition of the credit committee was herself as chairperson, accused 2 and 6 applicant, among others. Further, she testified that Panduleni CC was paid 1,450,000. She did not receive any money from Enecon, Irongo, Petroleum CC, or Oshali CC personally. She was not a member of Panduleni CC and she had no role to play in the affairs of the CC. There was no money transferred to her personal bank account. Panduleni CC, there was no money transferred to her personal bank account. She does not know the owner of Quality Meat CC. She was aware of the payments from Panduleni CC to their mortgage bond, and she did some payments, and that is their house. She was aware that there has been payments from Quality Meat CC to Panduleni CC and was a co-signatory to the latter's bank account in her capacity as the wife to accused 8 in order to attend to any payments as needed for farming activities. She was not aware about anything else other than farming activities. On count 21, she made payments and she was authorized, she testified. As executive of finance, supporting documents were brought before payments were made. On the payments of 53.2 million, she had the following documents. 1, the request prepared by the 6th applicant, signed by the 4th applicant as MD, stating that Namcor has made budgetary provision for 25 million and 40 million for business development as approved by the board for the acquisition of the assets. The budget for Namcor includes budget for the 2 subsidiaries, and these validated the payment. 2, asset evaluation report. The internal memo which highlighted existence and value of the assets. In fact, another report contained the pictures and signatures of Enecon, contained the pictures and signage of Enecon prepared by Mr. Shafeni, who is not before court. 53.2 million was paid. 3, independent asset evaluation report by Seal Engineering confirming the assets and the value was higher than that which they paid. 4, fixed asset register in brackets FAR, submitted with a letter from the accountant of Enecon. Ducatus confirming the correctness of the FAR. 5, the feasibility study by Mr. Sam Hashela. 6, APA. She had it before authorizing the payment and it was signed by the 4th applicant as MD. Clause 2 or 3 of the APA states that 35 million to be paid to Namcor, and she went through the agreement between Enecon and MOD, and there was no incumbent asset. The FAR was evidence that the assets belong to Enecon because the accountant will not recognize assets that do not exist without economic benefits and value. Further, the 5th applicant testified that she did not misrepresent nor did she pretend to anyone based on the information she presented to the court. Further, when authorized signatories make payments as a control measure for Namcor, there are 2 independent signatories that release the payments. If the payment is above $1 million, 2 A signatories, meaning 2 executives, duly authorized must approve the payment. The check requisition for 19 July 2022 had supporting documents. She checked and approved Sam, and it was approved by 2 persons. There is a preparer of the payment, the assistant accountant. It is then checked by the financial accountant and then the finance manager. It is then checked by herself as the finance executive and approved by 2 signatories, herself and another. The board has 2 independent signatories, independent from finance. She authorized payment into Enecon's account and then passed same to Mr. Shefeni. She cannot say why only her, because it was approved by 4 people who signed it. There was no unauthorized except the reallocation. The 4th applicant was duly authorized to enter into agreement both for the holding company and subsidiary, and his authority as far as entering into agreements has no limit. 53 million was paid and the 4th applicant was duly authorized. All documents were authorized and she was authorized to release the payment. Even when she released the payment, she was duly authorized as an A signatory. On count 23, she testified that the statement that she had access to Enecon's bank account from 26 October 2021 was totally not correct. Excuse me, was technically not correct. The account was opened on 26 October 2021. The purpose of Enecon board resolution was that she can be added as signatory. It only gave this authority when the FSA was signed on 16 March 2022. At the time, she had no authority only on 16 March 2022. The allegations is false. Clause 3.1.1 gave her the authority. There was a session between Namcor Trading, Enecon, and EcoFuel CC. She highlighted 3 things: registration 2000/421, and that there was a board resolution that the MD was duly authorized effective 2 March 2022. EcoFuel CC owed Namcor Trading 73.3 million Namibian dollars. And there was a board approval. The charge sheet states 70 million, and there was a board resolution for payment arrangements in the amount of 500,000. there were payments from Enecon to Namcor. That is why there is a difference from 73 million to 70 million. The date 2 March 2022 was not correct, and the date was taken over on that date. That agreement was approved by the board. The date did not accumulate between 2 March 2022 to 2 December 2022, but it was taken over on 2 March 2022, she testified. Further, the fifth applicant testified that Irongo Petroleum CC's bank account is 8019151399. She highlighted the credit committee authority at page 308, stating that they have to understand the liquidity, the solvency and efficiency of the customer when making the decision. It was her evidence that the policy does not dictate credit limit, but the committee based on the customer's needs. The policy was silent on how to give. However, if the limit was above 500 million, the MD must approve. Yes, there was a limit, a credit limit for Irongo Petroleum CC and approver. They are allowed to exceed the credit limit. The committee dictates and the policy is silent. She noted payment from Irongo Petroleum CC amounting to 7.3 million on 5 and 29 July 2022. She also observed payment from August 2022 until April 2023 and testified that Irongo Petroleum CC was paying until she left and when the fourth applicant was suspended. As such, they could not have caused the financial loss. It is what happened after the interim management came in, she testified. As far as they know, the account was out of credit limit and Irongo Petroleum was paying, but paying on monthly basis. Irongo Petroleum was buying but paying on monthly basis. It was false that they were giving Irongo Petroleum fuel for free. She disagreed that the respondent has a strong case. The charges are baseless, contains inaccuracies, timelines when they were not at Namcor. On count 24, she did not receive any money from Enecon. She was only a signatory to Panduleni CC, and the said CC has no limitations to trade. Panduleni CC did not transfer any money into her personal account. On count 25, she was not at Namcor in May 2023, and she did not conspire with anyone. 53 million was not paid into her personal bank account. Now, with regard to public interest, in brackets, with regard to public policy, in bracket, interest, the fifth applicant testified that the public was smart enough to see what was transpiring here, in brackets, in court. Their, in brackets, applicant's story did not change. They acted within their mandate of credit policy and were duly authorized. Where they made mistakes, the contract of employment says disciplinary hearing, not prosecution. The fourth applicant told her in 2024 that a police case was open and she knew that they could be called or arrested. She did not try to run away, and she will not run away because this was done in the ordinary course of business. It was not in the public interest to keep a mother with 3 minor children in custody. Since she left Namcor, she has moved on and has no interest to interfere with witnesses or investigation. Documents are on record, she testified. Finally, she testified that she can afford bail in the amount of 10,000 Namibian dollars. Her passport was with her counsel of record, and she has no issue with reporting convictions. Now, as stated above, the 6th and 7th applicants brought their bail applications by way of affidavit, and same forms part of the record as exhibits F and G. The 6th applicant stated in her affidavit that she is ordinarily resident at number 17 Northern Valley Ambrose Street, Klenekupe, Windhoek. She is currently unemployed and unmarried. She occasionally conducts consultancy services for various individuals, including juristic persons. She is a mother of a 24-year-old male presently studying in Spain. All her relatives are in Namibia, and she has no assets outside Namibia. She owns a motor vehicle and an immovable property in bracket flat, registered in the name of a closed corporation known as Abentier Street Properties CC, of which she holds 100% members' interest. She is amenable to surrender her travel documents to the investigating officer, and she undertakes not to apply for new travel documents. She can afford bail in the amount of 10,000 Namibian dollars with conditions. Further, the 6th applicant stated in her affidavit that she was arrested on 8 July 2025 at around 17:19. In other words, 19 past 1700 hours. She received a call from a certain Inspector Anna, who identified herself as a police officer and informed her that she wanted to drop an envelope with her, and she was with the ACC official. She was then requested to come to Windhoek station, which she did. Upon arrival, she was informed that she was under arrest. She requested to call her legal representative, but she was informed that her colleagues were already arrested and her legal rights were explained without more. She was informed about her reasons for arrest, which was because of fraud and money laundering, without any further details about the allegations. She was allowed to make a call to arrange for a motor vehicle to be collected, and thereafter Inspector Anna demanded her cell phone, the PIN and the password. She also asked whether that was legal, but she was informed that both her and her property were now state properties. Her request to call her legal representative was denied. Further, she stated that she was aware about the investigations, and she had all the time to flee if she wanted, or if she had such intention. With regard to the charges, the 6th applicant stated in her affidavit that she will tender a plea of not guilty at the trial to all the charges leveled against her. The state believes that they have a strong case against her, but it is a weak one. It has been established that the so-called serious charges can best be described as being chaotic, poor, and absolutely shambolic for the following reasons. She was an employee of Namcor Trading and not Namcor, as the state alleges. She had no authority to increase any credit limit, and certainly she increased no credit limit as alleged. She joined Namcor Trading during October 2019, and at that point, Eco Fuel was already conducting business with Namcor Trading. She denies that she corruptly used any public office for gratification and that in any event she occupied no public office. She is also aware about the sale, she is also unaware about the sale of 9 service stations, but there was an APA between Namcor Trading concerning the rights, title, and interest to assets owned by Enecon. The transaction was foreshadowed by the FSA. She was tasked by Davis Mofaso, in bracket Mofaso, to prepare the internal memorandum dated 8 July 2022 after considering the report and financial feasibility study prepared by Mr. Shafeni and Mr. Hashela. She was convinced the said documents made a good business case and supported the transaction. In any event, the memorandum was simply a recommendation, she stated. Further, the 6 applicants stated in her affidavit that she had never conspired with any of her co-accused or anybody for that matter. The state failed to specify the person to whom she may have misrepresented. She confirmed at paragraph 2.7 of her affidavit payment from an entity known as Venus Technology CC on 4 August 2022 in the amount of 10,000 Namibian dollars. The payment was not for any moment in respect of any Namcor trading or Namcor related matter. The payment was made in respect of consultation she did in relation to a feasibility study for an intended medical center. Further, she stated in her affidavit that she was advised not to deal with the merits of the charges at this stage of the proceedings. The allegations lacked substance and factual basis. The presumption of the law is that she was innocent until proven guilty in a competent court, and she cannot be kept in custody as a form of anticipatory punishment. Further, she stated that she is not a flight risk. On her face appearance, it was submitted that investigations in this matter were finalized. This blows apart the state's ground of objection that they will interfere with investigations. It was imaginary and unsubstantiated for the state to fear that she will interfere with investigation. She is unaware of who the state witnesses are. Further, the 6th applicant stated that she did not endanger the safety of the public or commit any offense. She has no intention to abscond, and she will not interfere. She will not, influence any person or destroy any evidence, and neither will she undermine the criminal justice system. Further, she stated that she does not dispute the seriousness of the charges. However, she was advised that the charges at this stage is simply a label and not conclusive of anything. She is presumed innocent until proven guilty in a competent court of law. Section 61 of the CPA only find application in respect of any offenses referred to in Part 4 of the schedule. She will stand her trial and not abscond. Finally, she stated that her release is in the interest of justice and that she has proven that exceptional circumstances exist justifying her release on bail. The seventh applicant stated in his affidavit that he is residing at F4834 extension 24 Ondangwa, which is owned by his cousin. He was born in Onamulunga village, Oshikoto region. He has a valid passport and is currently in the possession of his council of record. He is a qualified plumber by profession. He has no relatives and assets outside Namibia. He is a father of a 9-year-old child, and he is responsible for her upkeep. He is self-employed as a plumber, earning about 10,000 Namibian dollars. He can afford bail of 5,000 Namibian dollars. He does not own any immovable property, but he is in the process of constructing one at Onamulunga village. He has no pending case or previous conviction. His ties are in Namibia. Further, he stated that he was arrested on 10 July 2025. He received a phone call from the ACC investigators requesting to meet them at Ondangwa, which he did, and he was arrested. With regard to the charges, the seventh applicant stated in his affidavit that he is charged with 2 counts. However, it became apparent that during submissions, his counsel of record confirmed that he was charged with 3 counts. He denies the allegations against him, and he intends to plead not guilty to the charges during the trial. He stated further that he was advised not to deal with the merits of the charges at this stage of the proceedings. However, he deemed it appropriate to deal with the merits. He stated that at some time towards the end of 2019 or beginning of 2020, Austin approached him with an idea of registering a petroleum company. Resultantly, a close corporation named Petroleum Irongo CC in brackets, Irongo CC, with its principal business being the supply of all petroleum products, import and export, and transportation, was registered. On registration of Irongo Petroleum CC on 13 February 2020, he held 40% membership interest. Saima Emmanuel, in brackets Saima, 40% membership interest. And Matthews Panduleni Iyambo, in brackets Iyambo, 20% interest. On 23 November 2020, the amended statement indicates that he held 70% membership interest, whereas Iyambo and Christina Ndafenengo, in brackets Ndafenengo, held 15% membership interest each. Paragraph 38 and 39 of his affidavit reflects that on 14 May 2022 and 27 October 2023, he held 100% membership interest. On 13 November 2023, he held 30% and Austin 70% membership interest. On 15 February 2024, Austin held 100% membership interest. Further, he stated that Iyambo and Ndafenengo ceased to be members of Irongo Petroleum CC on 27 October 2023. He stated further that at paragraph 44 that during the period December 2022 until May 2023, the members and authorized signatories of the bank accounts were himself, Iyambo, and Dafenongo. The state's allegation that he was 100% shareholder was factually incorrect. Further, the seventh applicant stated that during his tenure as member of Irongo Petroleum CC, he played no role in the operations of the business, apart from signing documents that required the signature of the members. The operations of the business were attended to by Austin, and members would sign special powers of attorney which enable Austin to deal with lawful aspects of the business. The specified power of attorney granted Austin broad authority to act on behalf of Irongo Petroleum CC as depicted on paragraph 48 of his affidavit. One such power of attorney was signed on 27 June 2022 by himself, Saima, and Iyambo. Even though he was a signatory to the bank account, he had no access to such bank accounts, as such access and power was granted solely to Austin, nor did he have online banking access. Therefore, he could not have made payment of $500,000 on 17 December 2022 to Quality Meat CC in terms of count 60. He does not know who made such payment, and it appeared to be an electronic fund transfer. He denies making such payment both in his personal capacity and on behalf of Irongo Petroleum CC. Further, he stated that the state does not have a prima facie case against him. Count 61 was more worrisome as it lacked material allegations, such as to whom the misrepresentation was exactly made. Based on the statements provided by the state, Irongo Petroleum CC made payments to Namcor of about 93.6 million on his count. Therefore, the state does not have a strong case against him. Irongo Petroleum CC and Namcor Trading had an FSA. Further, the seventh applicant reiterated that at no point did he interfere with investigation, and the identity of the witnesses and suspects are unknown to him. The case against him is very weak. He will not endanger the public and will not attempt to evade, and neither will he attempt to influence, intimidate, or destroy any evidence. He will abide by bail condition. Now the respondent's case. From the onset of the proceedings, the respondent disclosed his ground of objection to the release of the applicant on bail as follows. 1. Risk of abscondment. 2. Fear of interference with witnesses and or investigations. 3. Seriousness and strength of the state's case. And 4. Not in the public interest or interest of the administration of justice that the applicant should be granted bail. The investigating officer testified that he is employed by the ACC. He started working for the Namibian police, in brackets Nampol, in 2000 for 8 years until March 2009. Thereafter, he joined the ACC for the first time as an investigating officer until 2012. He joined Standard Bank Namibia from 2012 to 2020 as a manager for forensic investigations. In November 2020, he again joined the ACC as the chief investigating officer to this date. He is the investigating officer in this matter. It all started, he testified, on 7 February 2024 when he was assigned to investigate an anonymous complaint reported to the ACC that accused two may be involved in corrupt practices. For he was depositing large sums of cash in his bank account. He was then assigned as the investigating officer to look into the allegation. The ECC also received a case docket, Windhoek CR 379/04/2024, referred from Namcor. Ironically, accused 2 was also listed as a suspect in that docket, which was different from the anonymous complaint. Further, the investigating officer testified that there were too many allegations in the docket. Firstly, that Namcor staffs accused 2, 5th and 6th applicants and procedurally without following Namcor procedures supplied petroleum products to Enecon and Irongo Petroleum, CC. Further, it was alleged that the supply took place between 1 August 2022 and 4 May 2023, and the value involved at that time was 277 million, rounded off. Secondly, it was alleged that the 4th applicant had corruptly and fraudulently abused his office and position as MD of Namcor, and he entered into an APA with Enecon and on 18 July 2022 without having followed internal policies of Namcor, including the procurement policy. The 4th applicant failed to follow the financial, procurement, and budget policies in that he acquired or attempted to acquire the fuel storage facilities, in brackets, assets from Enecon to the value of 53.2 million. The complainant in this docket was Mr. Engelhard Kongoro, the then Namcor board member and chairperson of the Finance and Audit Committee, a subcommittee of the board responsible for Namcor Trading, a subsidiary of Namcor Holding. The complaint was reported after an internal investigation was concluded by Namcor, after it was anonymously reported during April 2023 that Namcor had acquired the assets, but they were not known to the board. The investigating officer testified that the investigations were done jointly with Namcor, to which the ACC was the lead investigator, and he was assigned to investigate the two cases together. Further, the investigating officer testified that on 19 November 2021, Enecon provided a credit guarantee of 5 million to Namcor, and that was the beginning of the relationship between the two. As part of Namcor's credit policy, when a customer applies for a credit facility, a credit guarantee is undertaken by Namcor to mitigate losses. A credit guarantee serves as collateral provided by the customer, and if the customer defaults, Namcor can then recall the guarantee to reduce exposure of the losses. Further, he testified that after the 5 million guarantee was granted, Enecon was given a credit limit of 5 million, which was equivalent to the credit guarantee provided by Enecon to Namcor at the time. However, the credit guarantee was short-lived, and it was cancelled on 29 November 2021. Evidence indicates that the credit guarantee was cancelled by the 5th applicant as there was something wrong with the guarantee and he was not sure what was wrong. Subsequently, the credit guarantee to Enecon was zero rise, meaning that if Enecon needed petroleum products, they had to pay cash. That was the case from 15 December 2021 until 2 March 2022, when EcoFuel CC ceded all its debts and liabilities to Namcor to the value of 73 million. There was a resolution attached dated 2 March 2022 by Enecon in which it was resolved to take over the liabilities of EcoFuel CC. One of the resolutions was that Enecon would negotiate for the exclusive fuel supply with Namcor, which was done on 16 March 2022 when Enecon entered into an FSA with Namcor. And they were provided with a credit limit of 15.2 million. The directors of Enecon at the time were the first and second applicants, as well as James V. Awala. Further, the investigating officer testified that it was important to mention that when Enecon was given a credit limit of 15.2 million, they did not provide a credit guarantee of the same amount. It was agreed in terms of the FSA that Enecon would use government purchase orders as a guarantee. All purchase orders issued by Enecon to Namcor would be accompanied by the government purchase orders issued by MOD. Failure to include government purchase orders meant there will be no petroleum products to be issued to Enecon. This was a safety mechanism for both parties, and more so since there was no credit guarantee by Enecon, and it was to protect Namcor from fuel losses. Further, one of the conditions was that the fifth applicant would be granted access to Enecon's account number 520, which was also serving as another level of security so as to ensure that money is deposited, so that to ensure that once money is deposited by MOD, her role was to debit Enecon and credit Namcor's bank account. The investigating officer testified that, interestingly, when they obtained the account statement of Enecon, it was opened on 26 October 2021, which was before the commencement of the relationship between Enecon and Namcor. The resolution of Enecon dated 26 October 2021 was used, in which the fifth applicant was granted access to the new bank account. The resolution did not indicate why the fifth applicant was granted access to the said bank account, and this was done at least 5 months before the FSA between Enecon and Namcor. There was no authorization from Namcor authorizing the fifth applicant to be a signatory to Enecon's bank account. Further, the investigating officer testified that Enecon became a customer of Namcor. They had a debt of 73 million, seeded by EcoFuel CC. Enecon was then given a credit limit of 15.5 million, which meant that they could take petroleum products from the 0 to 15.5 million. The earliest evidence, 10 May 2022, 2 months after signing the FSA, Namcor was planning to acquire the fuel storage facilities. The fourth applicant authorized Mr. Michael Aipanda and Shefeni from Engineering and Technical Services to visit the 9 military bases to conduct an evaluation of the assets that Namcor intended to buy from 11 to 19 May 2022. Subsequently, the two staff members visited the sites accompanied by Enecon employee Mateus Iyambo. An evaluation report of the assets was produced. There was also a verification of the evaluation of the technical team by SEAL Consulting, and there was a difference in the values of the two reports. The technical team valued the assets as 53.2 million and SEAL Consulting at 54 million. In addition, there was a discounted cash flow report by Hashela on the instructions or request of accused 2 and 6 applicants to make projections whether the undertaking was commercially viable, dated 6 July 2022. Further, he testified that, interestingly, between 16 March 2022, when Enecon entered into the FSA with Namcor, until July, their debt rose to 35 million, almost 20 million above the limit without a credit guarantee. The investigating officer testified further that following the discounted cash flow report, the 6 applicants wrote an internal memo, random dated 8 July 2022, motivating Namcor, in brackets, Namcor Trading, to acquire the assets. The submission was submitted by Maposa and accused 2, accompanied by recommended by Sefeni and approved by the 4th applicant. Following the approval of the 6th applicant submission, a commercial offer was made by the 4th applicant on the even date 8 July 2022 to Enecon, and it was subsequently accepted by the shareholders, in bracket, directors of Enecon, the first and second applicants. The commercial offer was made by the 4th applicant and the MD of Namcor and its subsidiaries. The commercial offer to Enecon was very specific. Namcor wanted to buy assets valued at 53.2 million, and the nature of the assets was described in the same commercial offer, which was accepted by Enecon. After the offer was accepted, a contract was prepared by Namcor's legal team. No other procurement process was done. The contract was signed by Enecon's directors on 15 July 2022, and the 4th applicant signed on 18 July 2022. Interestingly, he testified there was an instruction as far as the payment of the 53.2 million was concerned, to be paid into separate transactions. 35 million to be paid into bank account number 520, and the 18.2 million to be paid into bank account 848. Bank account number 520 was the one where the 5th applicant paid 150,000 Namibian dollars from Irongo Petroleum CC via Quality Meat into his personal bank account at Standard Bank. at the time this transaction was made, Irongo Petroleum CC was 100% owned by the seventh applicant. Quality Meat CC membership interest since inception was held by Hileni Itana, in brackets Hileni 100%. They visited the given address of Quality Meat CC because they thought it was a butchery, but there was no butchery. It was only a residential area. A residential address at 38 Fumbe Street, Mbambasia. BIPA documents indicates that the beneficial owner was Malima. Quality Meat CC's bank account, Quality Meat CC's bank, Windhoek bank account signatory is Malima, who is out of the country. Investigations are ongoing. Further, the investigating officer testified that after the APA was signed by the fourth applicant on 18 July 2022, no procedures for procurement and budget were complied with. On 19 July 2022, at about 09:17 a.m., the invoice of 53.2 million was sent to the fifth applicant by Rebecca Erasmus from Enecon, and she sent the same to accused 2 and 6 applicant by email to certify same. It was also sent to Martha Shikongo, in brackets Martha, by the fifth applicant with instructions for her to initiate the process. Subsequently, accused 2 certified the invoice for the purchase of the assets in respect of the payment, and Mafosa certified same on behalf of the 6th applicant as she was not in the office. The assets were encumbered to MOD by agreement signed on 15 September 2006 under correction, he testified. Part of the investigation was to verify the allegations, and they visited MOD. First, they had to verify the agreement between Eneken and MOD on the supply of fuel, and secondly, the purchase orders issued by MOD in favor of Enecon and invoices received by MOD from Enecon from 1 August 2022 to December 2022. The investigations established that indeed there was a 15 years agreement, and the allegations were confirmed that there was an FSA between Enecon and MOD ending in 2031, and it was still in force at the time. The investigating officer testified further that it was evident through investigations that Enecon did not tell MOD that they were selling the assets sold to Namcor, which assets were situated on military bases. Further, the agreement stated that the assets will become MOD assets by 2031. MOD only became aware that after the minister inquired from the executive director, in brackets ED, after learning about a civil case in the High Court. MOD tried to seek clarity from August 26, an entity owned by MOD. Further, the investigating officer testified that interestingly, these were the very assets sold by Enecon to Namcor. In actual fact, from 19 July 2022, when payment was made to April 2023, when the fourth applicant was suspended. The acquisition of the assets was unknown to the board, or in fact to the entire Namcor. as it was only reported anonymously in April 2023. When Namcor board became aware that Namcor Trading acquired these assets, despite the acquisition of the assets, it was business as usual as Enecon continued to supply fuel to MOD despite the sale of the assets on 18 July 2022. He testified that until today, Namcor has never received or enjoyed any benefit for having acquired these assets, and a question can be asked, why were these assets sold to Namcor in the first place? He testified. On 19 July 2022, after the invoice was certified, 2 transactions were made as stated to earlier, 35 million Namibian dollars into bank account 520 and 18.2 million into bank account 848. As per the agreement, the 35 million was paid back to Namcor to offset the debt of 35 million incurred by Namcor following the FSA of 16 March 2022. Enecon only had a credit limit of 15.5 million in terms of the FSA. By 19 July 2022, they had exceeded the credit limit and the debt stood at 35 million. 73 million was ceded by EcoFuel CC to Enecon, and the total exposure in terms of value stood at 108 million. Further, the investigating officer testified that immediately after payment was received by Enecon, 3,613,000 was paid on the same date into a bank account of Onyeka CC owned by the second applicant and accused 7, or then third applicant, 50% membership interest each. From that amount, the first and second applicants were paid 1.5 million each into their personal bank account held at Bank Windhoek. The signatories of Onyeka CZ are both the first and second applicants, as well as accused number 8, in brackets, third applicant. Further, the investigating officer testified that 9.5 million was paid by Enecon to EcoFuel, to Eco Trading CC, which is 100% owned by Malema, and these funds was disbursed to various entities. On 20 July 2022, 1,040,000 was paid to Parkwood Petroleum CC, which is 100% owned by accused 2, who at the time was still employed by Namcor as manager of supply and logistics. This was the same money paid by his employer Namcor at the time. 1,470,000 Namibian dollars was paid to Bank Windhoek account of Quality Meat owned by Helene, to which Malema is the beneficial owner and signatory of the bank account. Further, the investigating officer testified that when the money was received by Quality Meat CC, immediately an amount of 960,000 Namibian dollars was paid to accused 2's personal bank account held at Bank Windhoek. This was the very money paid from Namcor to Enecon, Eco Trading and Quality Meat CC, and ended up in accused 2's personal bank account. Of the remaining balance, of the remaining balance of 510,000 Namibian dollars into Quality Meat bank account CC. 500,000 was paid into Panduleni CC, which is 100% owned by accused 8, who is also the husband to the 5th applicant, who was at the time the executive for finance and administration at Namcor. In order for the 53.2 million to leave the bank account of Namcor, it was approved by the 5th applicant, he testified. Further, the investigating officer testified that 1.5 million was paid to Eco Trading, that 1.5 million paid from Eco Trading to Eco Fuel CC. Eco Fuel CC is owned by Johanna Amunjeko and Martha Aintindi. The amount was withdrawn in cash in 2 parts on 20 July 2022, 700,000 and 800,000 by Connie van Wyk, accused 10. The signatories to the specific bank account into which the money was paid were Austin, that is accused 11, and accused 10. The addresses for Eco Fuel and Eco Trading are number 15 Hammerskorp Street, which happens to be the address for the first applicant. 2 additional payments were made by Enecon to Onyeka CC of 200,000 in total between 19 and 25 July 2022, which resulted in Onyeka receiving 3.8 million Namibian dollars from Enecon in total. An amount of 213,000 Namibian dollars was paid by Onyeka CC to Nyambali CC, which is owned 48% each by the first and second applicants, and the remaining 2% by a certain Adele. Of the above amount of 212,000 Namibian dollars was paid to Development Bank of Namibia in brackets DBN. The signatory to Nyambali CC are the first and second applicants. On 20 July 2022, 1 million, part of the money from Namcor, was paid to Venus Technology CC, which is 100% owned by Austin. Part of this money, 10,000 Namibian dollars, was paid by Venus Technology CC into a savings bank account of the 6th applicant in August 2022. Further, there were cash deposits added to the said amount in brackets in Venus Technology CC bank account, and that money was used to deposit a vehicle in 1,184,000 Namibian dollars used to pay a deposit on a vehicle bought by Austin. The vehicle changed ownership and investigations are ongoing at the moment, he testified. Further, 1.2 million was received by Eco Trading and it was paid to Oshali Fuel Investment, CC, in bracket Oshali Fuel CC, owned by Simeon Haingela Nangolo. The said amount was subsequently paid to Namcor by Oshali Fuel CC. Further, the investigating officer testified that having looked at how the funds received from Namcor was distributed, taking into consideration that Namcor bought assets which they never used from 18 July 2022 to date, it was concluded that the APA was simply a vehicle or instrument that was used to enable the money to be paid from Namcor Trading. Namcor had the opportunity and So did the fourth applicant from 19 July 2022, when funds were paid until he was suspended, but did nothing. Evidence indicates that some of those funds went into the pockets of staff members and or indirectly to relatives or husband of the fifth applicant. If one adds the amount of 960,000 Namibian dollars received into the personal account of accused 2 and 1,040,000 Namibian dollars paid into an entity which is 100% owned by him, it means that accused 2 received gratification of at least 2 million Namibian dollars, he testified. Accused 2 was instrumental in the acquisition of the assets bought by his employer. He recommended the submissions for Namcor Trading to acquire the assets, and together with the 6th applicant, they arranged and instructed Hashela to compile the discounted cash flow report. These activities were done in their official capacity, yet ended up receiving gratification from the same entity. Further, the investigating officer testified that similarly, the 5th applicant approved the payment in her official capacity, following which 500,000 Namibian dollars was paid to Panduleni CC, which is held 100% by accused 2, by accused 8. An amount of 646,000 Namibian dollars was paid into the home loan of the 5th applicant and accused 8 from the money received from Namcor Trading. Further, the investigating officer testified that investigations revealed there was misrepresentation by the 2nd and 3rd applicants in that they did not disclose that Namcor could never take ownership of the assets that Namcor was buying, because when the commercial offer was made on 15 July 2022, in brackets 18 July 2022, Namcor Trading specified what they wanted to buy. Before Enecon accepted the offer, they had the opportunity to change or indicate that they were not selling, or Namcor Trading could not buy the assets as per the offer. Similarly, even on 15 July, when they signed the agreement, they had the opportunity to specify what exactly they were offering to Namcor Trading, which was not recovered to this date. Excuse me, but that, I'm going to take it again. Similarly, even on 15 July, when they signed the agreement, they had the opportunity to specify what exactly they were offering to Namcor Trading, but that was not done. That caused Namcor Trading to suffer losses of 53.2 million, which was not recovered to this date. Further, the investigating officer testified Enecon did not sell anything to Namcor to this date. Enecon used part of the 53.2 million to offset the date. Basically, it paid Namcor's debt with Namcor's money in his own word. Namcor never took ownership of any assets, he testified. This was enabled by the 4th applicant in the sense that he bypassed all procedures to have that contract signed. If Namcor Trading never took ownership of the asset they intended to buy, there was no urgency in not having followed the procedures, he testified. He testified further that the 4th applicant was well aware about the acquisition from the time they started planning to buy the assets in May 2020 until he was suspended in April 2023. The fourth applicant failed to report the acquisition of the assets to the board. The investigating officer testified further that evidence has shown that there was conspiracy, meaning there was a plan between Enecon, in bracket, the first and second applicants as directors who accepted and signed the offer together with the fourth, fifth, sixth applicants and accused two. Hence, they did not do anything from the time the APA was signed until the matter was reported anonymously to the former Minister of Ministry of Finance, Mr. Shimi, who brought it to the board's attention. He testified further that nothing was done because Namcor Trading entered into an agreement to buy assets which they did not use or own, and it was business as usual by Enecon, supplying fuel to MOD using the same assets they sold to Namcor Trading. Partial analysis of all accounts was done, and that is how the ACC was able to conclude that there were corrupt practices, despite the Enecon's account being zeroized and 35 million was paid to Namcor. I'm going to take it again. Partial analysis of all accounts was done, and this was how the ACC was able to conclude that there were corrupt practices. Despite Enecon's account being zeroized, 35 million was paid to Namcor. Between 1 August 2022 to end of November 2022, Enecon's debt rose to 35.7 million again. He testified further that Mr. Kongoro's statement that the amount was 277 million, of which 38 million was alleged to be Enecon's fuel debt. During investigation, they went back to Namcor and they requested records and invoices in respect of the two entities, Enecon and Irongo Petroleum CC. The investigation officer testified that Namcor Trading was able to provide the investigation team with invoices totaling 35.7 million from 1 August 2022 to November 2022. These invoices were issued to Namcor Trading regarding fuel supplied to Enecon. Upon reconciliation, that is why they have different figures from those reported by Mr. Kongoro. The invoices were accompanied by respective purchase orders issued by Enecon to Namcor Trading and comprised of email approvals by members of the credit committee, the fifth and sixth applicants, as well as accused two. The investigating officer also noted that the condition that when Enecon issues purchase orders to Namcor Trading for fuel supply, such orders should be accompanied by the corresponding purchase orders issued by MOD. They could not find any corresponding purchase orders issued by MOD to Enecon as per the agreement in custody of Namcor Trading, meaning that fuel supply was contrary to the agreement because the agreement clearly stated that the FSA, the agreement clearly stated in the FSA that failure to issue corresponding purchase orders means no fuel would be supplied to Enecon. However, they have evidence that fuels were supplied to Enecon despite there being no purchase orders from MOD. The investigating officer testified further that the investigation team proceeded back to MOD in order to obtain evidence of the purchase orders issued by MOD for fuel supply to Enecon from 1 August 2022 to November 2022. The rationale was that one of the conditions in the FSA was that all invoices issued by Enecon to MOD should have bank account number 520. The purchase orders and invoices for the said period were obtained from MOD. Evidence showed that the invoices were issued by Enecon for that period to MOD using a different bank account, 848, which was contrary to the FSA conditions. The agreement was that invoices must have account number 520, which was a misrepresentation because the money would not have gone into the intended bank account. Further, the investigating officer testified that in order for the payment to be processed through a purchase order, there is a verification process by the government to curb incidences of fraud. There are markers and checkers within the finance stream. Part of these balance and checks is to verify that the money is paid to the account number listed on the invoice by the service provider. What it means is that an entity can have 2 or 3 listed accounts by the Ministry of Finance, and payment would be made to an account listed on the specific invoice at the time. He testified that it was noted during investigations that despite Enecon having incurred debts of 35 million as a result of the FSA signed on 16 March 2022 and taking into account that there was no credit guarantee provided by Enecon, it looked like Namcor Trading, through its credit committee members, in brackets accused 2, 5th and 6th applicants, allowed fuel supply from 1 August 2022 to end of November. Further, the investigating officer testified that in fact, Enecon has already demonstrated their inability to honor their date. Namcor suffered prejudice of 35 million, accused 2, 5th and 6th applicants failed to comply with internal policies when they authorized the credit for the supply of fuel to Enecon by Namcor Trading. Namcor Credit Committee had other members such as the head of legal, the manager for finance and the accountant. As such, any request should have come to the full credit committee. Although the other 3 members were not decision makers, they would have made recommendations either to approve or disapprove, and such was not done. The decision makers were accused 2, 5th and 6th applicants. The credit limit was sanctioned when a customer was onboarded to allow such a customer to receive products to a certain amount without payment. With regard to Irongo Petroleum CC, the investigating officer testified that part of the complaint received was that fuel was supplied to Irongo Petroleum CC, an entity at the time owned 100% by the seventh applicant. The transactions reported were from December 2022 to May 2023. Irongo Petroleum CC received petroleum products from Namcor Trading as per the agreement signed on 20 September 2022. Investigations revealed that at the time, Irongo Petroleum CC was given credit of 3 million Namibian dollars. And in November 2021, they applied to increase the credit limit. 10 million was approved. 2 credit guarantees were submitted, one for 6 million and another for 4 million, making the total of 10 million, meaning that Namcor Trading could supply fuel for 10 million without prejudice because the guarantee was sufficient. The investigating officer testified further that, however, the credit guarantee for 4 million Namibian dollars was recalled, but the credit limit remained the same at 10 million Namibian dollars. Evidence showed that Irongo Petroleum's profile from 20 December 2020 to November 2022 was good. Between December 2022 to May 2022, the account balance was 238 million. This means that Namcor Trading supplied fuel at 238 million, for which little payments were made. When the ACC started investigating Namcor investigations, Namcor Trading had demanded the guarantee for 6 million, and the total exposure to Namcor Trading was 238 million. That is 238 million minus 6 million comes to 238 million. Further investigations established that the approval process was similar to that of Enecon, where accused 2 5th and 6th applicants approved fuel above the credit limit. Evidence further established that there were payments made to 3 credit committee members by Irongo Petroleum when they were the people actually approving fuel supply to such an extent. Further, the investigating officer testified that between 27 May 2022, multiple transactions totaling 950,000 were made into the bank account of Panduleni CC owned by accused 8. Interestingly was the transaction of 500,000 made on 17 December 2022 by Irongo Petroleum CC through Quality Meat to Panduleni CC. It was his evidence that it was interesting because on 14 December 2022, the 5th applicant approved a purchase order in favor of Irongo Petroleum CC, where they received fuel valued at over 22 million. The investigations concluded that this was the result of the fuel approval by the 5th applicant. Similarly, accused 2 also received 1.6 million under correction, as he testified, from Irongo Petroleum through Quality Meat CC. The payments originated out of Irongo Petroleum CC between 15 July when he first received 150,000 Namibian dollars. The amount of 1.6 million comprises various transactions made between 15 July 2022 and November 2022. Further, there was an amount of 10,000 Namibian dollars paid during the first or second week of August 2022 to the sixth applicant by Austin. Although Irongo Petroleum CC was at the time 100% owned by the seventh applicant, there was a power of attorney authorizing Austin to make business transactions. The fourth applicant was suspended somewhere in April 2023 because of a number of internal investigations by Namcor, and one of those related to fuel supply to Enecon and Irongo Petroleum CC, he testified. Namcor placed a moratorium on further supply to the two entities. Fuel supply to Irongo stopped in November 2022. Despite the moratorium, the fifth and sixth applicants further authorized fuel to Irongo Petroleum CC. Further, the investigating officer testified that evidence shows that the fifth and sixth applicants were questioned about fuel authorization. The sixth applicant was not happy and she left and went to work for Irongo Petroleum CC. As they were busy with investigations, they received intelligence that a vehicle was bought by Malema for the fourth applicant. Evidence indicates that the vehicle was bought from OD Center Windhoek in 2023 and it was over 3 million Namibian dollars. A deposit of over 900,000 Namibian dollars was paid and he could still get the date and precise amount of the deposit, he testified. Sources provided photos of the vehicle. The fourth applicant have been using it and he personally saw the fourth applicant using it last year. They looked at the notice registration of the vehicle and they found out that it was registered under Helene. Further, investigation revealed that Helene is a cousin of the fourth applicant and in fact the namesake of the fourth applicant's mother. They contacted her and she confirmed that she does not own such vehicle. In February 2025, they visited OD Center and there were records that the fourth applicant has taken it for service. The vehicle is part and parcel of the ACC investigations and the reason is due to the relationship between Namcor and Malema. The relationship started in July 2018 when EcoFuel CC entered into a fuel supply agreement with Namcor Trading. EcoFuel CC was owned by Johanna Aintindi and another in 2020 at the time, and currently by Malema, who is also 100% beneficial owner. EcoFuel CC agreement resulted in the debt of 73 million being ceded to Enecon, on 2 March 2022. Malema is 100% beneficial owner of Eco Trading CC, Quality Meat CC, and Oshali Fuel. All these entities are recipients of funds that were originally paid by Namcor Trading for the acquisition of the assets from Namcor. Further, the investigating officer testified that from the 18.2 million paid by Namcor Trading to Enecon, Eco Trading received 9.5 million on 19 July 2022. It is apparent from the record that at this point, Mr. Namanje, on record for the first and second applicants, stated that the applicants have no issue if Mr. Lilungwe can lead his witness because most of the payments are common cause and not in dispute. Mr. Namanje continued that a number of witnesses have testified confirming those payments, including the investigating officer. The investigating officer confirmed that Exhibit B4 indicates that Quality Meat CC received 1,470,000 Namibian dollars from Eco Trading, and 500,000 Namibian dollars was paid to Panduleni CC on 20 July 2022, and 960,000 Namibian dollars was paid to accused two's personal bank account on 21 July 2022. Excuse me, on 21 July 2022. On 26 July 2022, 350,000 Namibian dollars was paid to accused two from Irongo Petroleum CC. The investigating officer testified further that Exhibit B5 reflects that Onyeka CC received 3,613,000 Namibian dollars on 19 July 2022, and the first and second applicants each were paid $1.5 million on the same date. Exhibit B9, the first applicant's bank account reflects that he received 1.5 million Namibian dollars as management fee. Exhibit B10, the second applicant's bank account also reflects that he received 1.5 million as management fee on the same date. The amounts were part of the 3,613,000 Namibian dollars paid to Onyeka CC, and it ended up in their personal bank account. Exhibit B6 is the bank account of Panduleni CC and reflects that Quality Meat CC made the following payments: 500,000, 100,000, another 100,000, and 500,000 on 20 July, 5 and 26 October, as well as 17 December 2022, respectively. The investigating officer testified further that Exhibit F reflects that Irongo Petroleum paid 10,000 Namibian dollars to the sixth applicant on 4 August 2025. They are looking at gratification. Fraud was a serious offense and it was committed while executing her duties. Further, the investigating officer testified that he was present when the second applicant was arrested. Namcor Nampol executed the warrant of arrest on both the second applicant and third applicant. Their legal rights and charges were explained when they were charged. He was present and explained the charges. The sixth applicant's appointment is part of the evidence. Whether she was employed by Namcor or Namcor Trading, this was about her conduct, he testified. On paragraph 2.2 of the sixth applicant's affidavit, he testified that there was documentary evidence that she approved the fuel supply to Irongo Petroleum CC and Enecon. On paragraph 22.3, the investigating officer testified that Namcor Trading is a subsidiary of Namcor, and he could not say whether Namcor Trading is a public entity. However, gratification does not matter whether a person is a public or private institution. On paragraph 22.4, he testified that the sixth applicant initiated this submission dated 8 July 2022. On paragraph 22.5, the investigating officer testified that conspiracy started when the planning for the acquisition of the fuel storage facility started. The 10,000 Namibian dollar paid to the six applicants' bank account was gratification, which was directly or indirectly. There was a strong case against her. Even if it was commercial transaction originally, the subsequent action makes it a crime. It was clear that the moment the matter came in terms of the APA, it was distributed to various entities held by the staff and their relatives. With regard to the seventh applicant, the investigating officer testified that evidence established that he held 100% interest in Irongo Petroleum CC. Irongo Petroleum CC entered into an FSA signed by seventh and fourth applicant. Irongo Petroleum received petroleum products of 238 million, and he believed that they have a strong case. He believed further that he was in agreement he testified further that he was in agreement that the normal course commercial contract would be, in the normal course, a commercial contract would be civil. The problem is that funds were being paid to staff members who authorized fuel to Irongo Petroleum CC and subsequently. With regard to paragraph 67 of the affidavit, he testified that he knew that the seventh applicant has a valid passport, but he did not know its whereabouts. Paragraph 68, he testified that it was correct that he presented himself to the regional office. However, he proceeded that he was not aware that he was going to be arrested. The investigating officer testified that the first applicant was one of the people who went to their office with his lawyer. The sixth applicant also brought herself to Windhoek station, but she did not know that she was going to be arrested. With regard to paragraph 72 and 73 of the seventh applicant's affidavit, he testified that they have sufficient evidence that he was involved and his entity received 238 million. He was 100% owner, however, he could not confirm that he was involved administratively. With regard to the grounds of objection, in particular interference with investigation, the investigating officer testified that the charges are serious and involves money laundering. They believe if the seventh applicant is granted bail, he will interfere. Fraud is a Schedule 2 offense, money laundering and contravening ACC Act. On paragraph 46, he testified that both entities, Enecon, EcoFuel CC, Irongo Fuel CC, and Onyeka CC, Quality Meat CC, and Irongo CC, and Venus CC, relationship was interconnected. Although the entities are registered by different persons, they are branches of the same tree. With regard to risk of abscondment, in particular, on the first applicant, he testified that the risk is there. The charges are fraud, conspiracy, money laundering, and he has the means of, in terms of funding. With regard to interference, he testified that this case was very complicated. This case involves complicated investigations, and there was very high degree of interference by the first applicant. On the aspect of public interest, it was his evidence that he was of the belief that the public is concerned with economic offenses due to significant impact on the economy and goes to how the world views Namibia. With regard to the second applicant, he testified that the risk of interference with investigations and witnesses is there. On the issue of abscondment, he testified that in investigations established that the second applicant lived in Dubai. As such, the risk of interference was there and the charges are serious. With regard to the fourth applicant, he testified that while the vehicle is not there, which was a sign of interference and the risk of, interference is there. The charges are serious and involves fraud, money laundering, corruption and have serious penalty. There is public interest, and he was the MD. Namcor suffered actual prejudice. On the fifth applicant, he testified that due to the seriousness of the charges, the likelihood of interference with investigation is there, given that she has been arrested, and if granted bail, she can interfere. With regard to the sixth applicant, he testified that some witnesses approached to obtain evidence are afraid, and the possibility of interference is there. The value involved in this matter is not small. Overall, the investigating officer testified that due to the seriousness of the charges, the risk of interference with investigations and witnesses exists. However, a number of suspects are still to be arrested. One suspect is on the run, and there is a likelihood of interference. The charges are complicated, and a number of assets were procured. Investigations are still ongoing, hence the fear of interference. Submissions by both parties. Submissions on behalf of the applicants. Written submissions by both counsels were handed into the record and form part of the record. As such, this court will not regurgitate same, but will only highlight when necessary. It is apparent that hotly contested submissions were made by both counsels. Further, it is also apparent from both submissions and opening statement that the applicants had no qualms with their arrest and detention, but the issue according to them was whether the arrest was necessary. It was submitted by Mr. Namanje on behalf of the first and second applicants that only one or two charges refer to section 332 in bracket 5 of the CPA. The state opted to charge his clients personally. Mr. Namanje submitted that if you don't rely on section 332 in bracket 5 of the CPA, a director cannot be held personally liable. It was submitted further that it was a commercial transaction, not a commercial. It was a commercial transaction and not a criminal matter. Further, it was submitted by Mr. Namanje that they have proved that the first and second applicants are good candidates for bail, and bail be granted in the amount of 50,000 Namibian dollars with conditions. Mr. Bangamwabo, on behalf of the fourth and fifth applicant, submitted that the applicants appears in a case termed the fuel road. However, there was no such thing as fuel road, but just sensation. He submitted that the first applicant was charged for pretending to have authority. However, the investigating officer testified that he had authority even up to 500 million. There were no bank statements presented for his clients, and neither did they receive any money. There was no criminal prosecution. There was no criminal prosecution for failure to comply with internal policy. The investigating officer testified that the vehicle in question was owned by Hileni, not the fourth applicant. Mr. Bangamwabo submitted further that the investigating officer testified that he never met the first applicant, but it was further his testimony that he also followed him, that he retracted his evidence. As such, his evidence should be approached with caution. And finally, it was submitted by Mr. Bangamwabo that the fifth applicant's crime is that money was paid into an entity 100% owned by the eighth applicant, and that the applicants have proved to be good candidates for bail in the amount of 50,000 Namibian dollars be granted. Mr. Casper, on behalf of the six applicants, submitted that the investigating officer's answer in cross-examination is final. He cannot retract. further submitted that public opinion should not be disregarded lightly. The ACC is a champion in fighting corruption and should be commended for the job because it's not an easy one due to public perception. However, that comes with inherent dangers because public opinion is not always informed by reason and it is not sound. The applicants are innocent until proven guilty, and that despite his strong case and seriousness, bail was granted to the other accused. And that's the Amshelelo case, placed the Amshelelo case on reliance. Further, he submitted that 50,000 Namibian dollars be granted to his client. Mrs. Gebhardt, on behalf of the seventh applicant, submitted that the court must lean in favor of granting bail. The seriousness of the offense lies in the sentence to be followed. The accused must not be kept in custody as a form of anticipatory punishment. Further, Ms. Gebhardt submitted that she was aware that the state will argue that her client brought bail by affidavit and that he was not cross-examined. He submitted that there was no factual dispute between the investigating officer's evidence and her client, that on the question of bail, the evidence of the investigating officer properly viewed supported her client's application for bail. The seventh applicant had contact with the suspect Malima before arrest. It was further submitted by Mrs. Gebhardt that the investigating officer contradicted himself in that her client had 100% membership interest in Irongo Petroleum CC from December 2022 to 2023, that the investigating officer ignored the paper amended documents of 2023. In a bold move, Mrs. Gebhardt invited the court to make an extempore judgment if so inclined and grant her client bail and reasons to follow later to avoid further prejudice. Now, it is opportune to state at this point that clearly that proof is for bail is that proof is not on a balance of probabilities, not beyond reasonable doubt. Reliance was placed on S versus Jürgen case. And finally, it was submitted by Mr. Lilungwe that bail should be refused in respect of the applicants. Now, the applicable legal principle. In S versus Penero, the court will not repeat the full citations on record because the citations are provided in the judgment. The court cited with approval a passage from Detroit et al. In commentary on the Criminal Procedure Act as follows. In the exercise of its discretion to grant or refuse bail, the court does in principle address only one all-embracing issue: will the interest of justice be prejudiced if the accused is granted bail? And in this context, it must be borne in mind that if an accused is refused bail in circumstances where he will stand his trial, the interests of justice are prejudiced. Four subsidiary questions arise. If released on bail, will the accused stand his trial? Will he interfere with state witnesses or police investigation? Will he commit further crime? Will his release be prejudicial to the administration of justice, law and order, and security of state? At the same time, the court should determine whether any objections to release of the applicant can be curbed by suitable bail condition. In Shekunga versus States, Sibea AJ as it then was held as follows. Bail applications are neither civil nor criminal proceedings, are sui generis and unique in nature, procedure and purpose. The use of affidavits in applying for bail without viva voce evidence is allowed as it is part of our law, and it is therefore endorsed. Further, the court cited with approval the decision in the Constitutional Court of South Africa in S versus Dlamini, S versus Dlandla, S versus Jobert, and S versus Shikat, where the court described bail in paragraph 11 as follows. Furthermore, a bail hearing is a unique judicial function. It is obvious that the peculiar requirements of a bail as an intellectually and inherently urgent step were kept in mind when the statute was drafted. Although it is intended to be a formal court procedure, it is considerably less formal than a trial, so the evidential material proffered need not comply with the strict rules of oral or written evidence. Also, although bail, like the trial, is essentially adversarial, the inquisitorial power of the presiding officer are greater. An important point to note here should be bail proceeding is so self-evident that is often overlooked is that there is a fundamental difference between the object of bail proceeding and that of a trial. In a bail application, the inquiry is not really concerned with the question of guilt. That is the task of the trial court. The court hearing the bail application is concerned with the question of possible guilty only to the extent that it may bear on whether the interests of justice lie in regard to bail. The focus on the bail stage is to decide whether the interests of justice permit the release of the applicant on bail. In Chizu versus S. Liebenberg A. Liebenberg J. as he then was held that the proper approach in deciding the risk of interference with state witnesses or investigations is to ask whether it is likely that the appellant will not interfere. In the Cleric versus the State at paragraph 18, it was held as follows. In order to curb the serious escalations of crime and the escalations of accused persons evading the course of justice by absconding, the legislature gave the court wider powers and additional powers to refuse bail in cases involving serious crime by amending Section 61 of the Criminal Procedure Act 51 of 1977. The said section provides as follows. If an accused who is in custody in respect of any offense referred to in Part 4 of Schedule 2 applies under Section 60 to be released on bail in respect of such offense, the court may, notwithstanding that it certified that it's unlikely that the accused, if released on bail, will abscond or interfere with any witnesses for the prosecution or with police investigations, refuse the application for bail if, in the opinion of the court, after such an inquiry as it deems necessary, it's in the interest of the administration of justice that the accused be retained in custody pending his or her trial. Now, it is tried law that a bail application may take any of the three processes, namely ex parte statements made by counsels from the bar, by filing affidavits and viva voce evidence. It is desirable that the applicant and the state should provide evidence to support their respective contentions. Obviously, an accused will have less an affidavit will have less probative value than viva voce evidence, which is subject to the test of cross-examination. At the same time, an affidavit will carry more weight than a mere statement from the bar. Further, it is tried law that in a bail application, the applicant bears the onus to prove on a balance of probabilities. The applicant must prove on a balance of probabilities that he or she is a worthy candidate of being granted bail, and that the interest of the administration of justice will not be prejudiced. If he or she is granted bail, the applicant or accused must specifically make out his or her own case and not necessarily rely on the perceived strengths or weaknesses of the state's case. However, this does not mean that the state is relieved of a duty to lead evidence in support of its objection to the release of the applicant or applicants on bail. Both parties in the bail application are under obligation to place factual materials before court to assist it in balancing the two competing interests and arrive at a fair and just decision to both parties. The accused, in brackets, applicants, are innocent until proven guilty in a competent court of law. Bail is not anticipatory punishment. The accused may be deprived of his or her right to liberty in accordance with the law, and each case be decided on its own merits. Now, analysis of the evidence. Now, from the onset, it must be made abundantly clear that this court will decide that this matter will be decided on the record before this court without fear, favor, or prejudice. As stated above, it is common cause that the parties entered into an FPA signed on 18 July 2022 for the purchase of the assets. The assets referred to are the home-based fuel facilities, including tanks, pumps, petrol attendants, houses, and all underground connections, as well as canopies. Whether one refers to them as home-based fuel station, home-based storage facilities or bulk storage facilities, it is essentially the same thing. The 9 home-based fuel storage facilities in MOD. Further, the second applicant testified during cross-examination that these are home-based stations that are in MOD. Further, even the first and second applicants in their evidence in chief at times referred to the assets as home-built service stations or fuel stations. In essence, in substance, the assets. On 19 July 2022, Namcor Trading made a payment of 52.2 million, and this is not in dispute. And so are all the other subsequent payments thereof, as depicted in the different bank accounts from Exhibit B2 to B10. The payments made into two parts, 35 million and 18.2 million into bank account 520 and 858 respectively. The 35 million was paid back to Namcor, and the 18.2 million remained with Enecon, and several payments were made thereof. In particular, an amount of 9.2 million was paid by Enecon to Eco Trading CC, which is 100% owned by Malema. On the same, subsequent payments were made to different entities, accused persons, and some of the applicants in this matter as set out at paragraphs 57 and 59 of this judgment above. And same are not in dispute. Just to highlight some of the payments, 1 million was paid to Venus Technology CC, and 1,470,000 was to Quality Meat CC on 20 December 2022. Upon receipt of the payment, Quality Meat immediately paid 500,000 to Panduleni CC, which is owned by accused Ed, the husband of the 50th applicant, and 960,000 to accused Two's bank account. A further 1,040,000 was paid to Pack House Petroleum CC, which is 100 by accused 2. Erongo Trading, Erongo Trading, and Erongo Trading CC, Enecon Feather paid, Enecon Feather paid Onyeka CC 200,000 between 19 and 25 July 2023, resulting in Onyeka receiving 3.8 million in total. An amount of 213,000 was paid to Onyeka's from Onyeka CC to Nyambali CC, which is 48% owned by the first and second applicant. Of this amount, 212,000 was paid by Nyambali to Development Bank of Namibia. An amount of 10,000, was paid to Venus CC on 4 August 2022 and subsequently paid to the 6th applicant. Further, it is common cause that Erongo Petroleum paid an amount of 350 million to Quality Meat CC on 26 July 2022, and the same amount was paid to accused 2 on the event date. Further, Quality Meat made the following payments: to Panduleni CC 100,000, 150,000, 100,000, and another 100,000, as well as 500,000, bringing the total paid to Panduleni CC to 1,450,000 between the period 27 May 2022 to 17 July 2022. On 15 July 2022, EPL Logistics paid 150,000 to Quality Meat, and the same amount was paid to accused 2 on. Further, on 26 July, an amount of 350 was paid by Erongo Petroleum CC to Quality Meat, and the said amount was paid to accused 2. It is also apparent that no payments were received by the 4th and 5th applicants in their personal bank accounts. It is apparent further from the above that the first and second applicants, as well as accused 2, received money through their business entities and personally into their bank account. The 6th applicant also received money into a personal bank account. The 7th applicant did not personally receive money, but Erongo Petroleum CC, to which he had an interest, not only received petroleum products valued at 238 million Namibian dollars, but also made several payments to accused 2 and his entity, 6 applicant, and Panduleni CC through Quality Meat and Venus Technology CC. That at the relevant the held 100% membership interest in due course fully. Accused 8, on the other hand, received money through Panduleni CC, to which he held 100% membership interest, and both him and the 5th applicant were signatories to the bank account. Further, it is also common cause that the 5th applicant approved payment of 53.2 million from Namcor Trading in her then capacity as executive, finance and administration, and part of this money landed in Panduleni CC, owned by her husband, accused 8, to which she was also a signatory to the bank account of the said CC. It's not in dispute that 643,000 Namibian dollars from Namcor Trading was paid to Panduleni CC, was subsequently paid to the mortgage bond of the property co-owned by the 5th applicant and accused 8. Further, the speed at which these payments were made also raises more questions. In other words, on the same date, 19 July 2022, when 53.2 million Namibian dollars was paid by Namcor Trading to Enecon, part of immediate and subsequently landed into into some of the applicants, accused persons, or suspects business entities, as well as some of the applicants and accused persons in their personal bank accounts. In particular, and subsequently to the first and second applicant's personal bank account. Further, 9.5 million was paid to Irongo, and subsequently 1,400,000 to Quality Meat CC, from which 500,000 and 960,000 was paid to Panduleni CC and accused 2 on 20 July 2022. Panduleni CC was paid, Irongo Petroleum paid 350,000 to Quality Meat on 26 July 2022, and on the even date, the same amount was paid to accused 2. Irongo Petroleum paid 10,000 Namibian dollars to Venus Technology on 4 July 2022, and on the even date, the same amount was paid to the 6th applicant. Irongo Petroleum also paid 500,000 to Quality Meat on 17 July 2022, and on the even date, the same amount was paid to Panduleni CC. As stated above, the payments to some of the applicants accused 2 and 8, as well as entities in which the hold interests are not in dispute. It was submitted by Mr. Namanje during evidence in chief of the investigating officer that the applicants have no issue with the payment and such are common cause. However, the applicants raise issue that this was a commercial transaction and does not call for criminal prosecution. According to them, it should have been settled in a commercial court or as per the contract. It was submitted by Mr. Namanje further in reliance to the respondent's submission that the applicant stated on face value that it was a commercial transaction. Mr. Lilungwe, on the other hand, for the respondent, submitted that a single action may give rise to both criminal and civil liability. It was correctly submitted that the state or respondent was not precluded from pursuing both criminal and civil liability. I pause to observe that the issue of a commercial transaction goes to the merit of the case, and it appears to this court that that issue is a part of the applicant's defense. Accordingly, it is an issue to be determined at the trial. It may or may not be a commercial transaction, hence the veracity of the totality of the evidence would not ordinarily beg consideration at this stage of to determine the strengths or the weakness of the state case. It is also common cause that Enecon sold the rights, title, and interest in and to those assets for 53.2 million to Namcor Trading. The said APA was signed by the first and second applicants as directors of Enecon and the fourth applicant on 15 and 18 July respectively. Namcor Trading paid the full amount on 19 July 2022. Further, as per the agreement, the amount 35 million was to Namcor. The investigating officer correctly testified that Enecon used part of the 53.2 million to offset the date. Basically, it paid Enecon's date with Namcor's money. Therefore, the assertion that Enecon paid Namcor Trading's date using the latter's money holds true, because that money came from Namcor Trading and it was paid back to Namcor on the same day. Further, the second and third applicants testified that Enecon was the owner of the assets and they remained owner until 2021 because they were built by Enecon's resources. During cross-examination by Mr. Lilungwe, the first applicant testified that Enecon built the assets on the basis of the agreement with MOD because they were granted 15 years to recoup their investment, and throughout that period, those assets, those service stations, in brackets, assets, even now belong to Enecon, and that is the practice in the oil industry. Whereas the second applicant testified during cross-examination by Mr. Lilungwe that they were having the rights, title, and interest in those assets. And that is what they sold. During cross-examination, it was put to the first applicant by Mr. Lilungwe, whose service station are those. He testified that they belong to MOD. We left those service stations and built new ones, new service stations with the equipment and the resources of Enecon. It was put to him that the state was not concerned with those that were decommissioned. He testified that they sold the title and assets that they put in and MOD was aware that those assets belonged to Enecon. When asked that earlier, he testified that they belonged to MOD and now to Enecon. Which one was correct? An objection was raised by Mr. Gaib on record for the first and second applicant, and after back and forth, the first applicant testified that those service stations, when they entered into the agreement, belonged to Enecon. It is apparent from the record to the old assets, to the old service stations by the new ones built by Enecon. As such, the first applicant firstly testified they belonged to MOD and later changed they belong to Enecon. Further, it is also apparent that the second applicant testified during cross-examination by Mr. Lilungwe that Namcor was entitled to use the facilities built by Enecon. He proceeded that the which Namcor enjoyed was to be an exclusive supplier of their products to MOD. However, it is apparent that Namcor Trading bought the assets, not the right to use or to be exclusive supplier in terms of the APA. The FSA and the APA were two different agreements, and the latter was only concerned with the purchase of the assets, not fuel supply. Asked, were you the owner? The second applicant testified that he did not know what Ms. Hinder meant by ownership, and he proceeded that they were having rights, title, and interest in those assets. Both the first and second applicant conceded that when the APA was concluded, the agreement with MOD dated 15 September 2016 was still in force. It is also apparent from the record that both the first and second applicant testified that Namcor Trading did not take ownership of the assets because they cancelled the agreement. During cross-examination, it was put to the first applicant by Mr. Lilungwe that until now, Namcor Trading never took ownership or use and enjoyment of the 9 service stations, in brackets assets, as a result of the APA. He testified that no, they went ahead and cancelled the agreement. And he also proceeded that the agreement was cancelled on 13 September 2023, and they never blocked Namcor Trading. During cross-examination, the second applicant was asked by Mr. Bangamwabo on behalf of the fourth and second applicants, did Enecon deliver the assets or allow Namcor to take possession of the assets? He testified, yeah, this is a commercial transaction. In the normal circumstances, the agreement should have an effective date. From that date, Namcor should have enjoyed the benefits, the titles, and the interest in those assets. He proceeded. A follow-up question was put to him by Mr. Bangama. But as owners of the assets? Did you ensure that Namcor enjoys possession as the new owner or the new possessor? He testified, yes, because we never prevented, in brackets, prevented Namcor to take possession. Asked by Mr. Bangamwabo. As we speak now, Namcor has taken over possession of the assets. The second applicant testified that they just learned that they cancelled the agreement. So they should have benefited up to now. They should have been having those benefits until now. The record above speaks for itself. It appears that the second applicant was just ducking and diving. Further, during cross-examination by Mr. Casper, the first applicant denounced that Namcor bought dreams. However, as stated above, it is apparent that Namcor did not get ownership or possession of the assets, contrary to his evidence that they did. Once the first and second applicants concede that Namcor did not take ownership or possession of the assets, it is settled. The above confirms the investigating officer's evidence that Namcor Trading never took ownership of the asset. Therefore, it is clear as daylight that Enecon did not deliver the assets. Put differently, Namcor Trading never took ownership of possession of the assets. This means that Enecon received the money, 53.2 million, and retained ownership of the assets in question. Even though Namcor Trading paid 53.2 million to acquire the assets in question, they never acquired them. A rhetoric question can be asked: why did Namcor Trading pay $53.2 million for if they did not acquire the assets? Further, the second applicant referred to a process to be followed because the assets were in MOD. However, it is apparent that there was no communication or consultation with MOD, and the first and second applicants testified they were not required to inform MOD. Further, it appears that both the first and second applicants testified that Namcor Trading made an offer and determined the price as they did an evaluation. However, at the same time, the first applicant testified that there was discussions and negotiation between him and as chairperson of Enecon and the first applicant, resulting in agreement of 53.2 million, and that was also confirmed by the letter. To the contrary, the first applicant testified that Namcor Trading acquired ownership of the assets. Further, the first applicant testified that they, in brackets, Namcor Trading, could not physically take possession of the assets because they are in various bases. In terms of clause 1.3 of the agreement, assets transfer shall or had to be effected on 18 July 2022, and from that date on, they remained assets of Namcor Trading. The above contradicts the evidence of the first and second applicants that Namcor Trading did not take ownership of the assets, is without merit and falls to be rejected as forthwith. In other words, the evidence of the first applicant that Namcor Trading enjoyed ownership or possession of the assets was a blatant lie. Further, the evidence of the first and second applicants confirms the evidence of the investigating officer that Namcor Trading did not acquire ownership or possession of the assets to this date. It is also apparent that the first and second applicants testified that the APA had no effective date. The record reflects that the second applicant was asked during cross-examination by Mr. Lilungwe that the effective date of the APA was 18 July. He testified that the agreement should be able to indicate the effective date and processes to be followed. He proceeded that they were not 100% sure what the agreement says. However, subsequently, he conceded that the effective date was 18 July 2022. The fourth applicant testified that the effective date was the date on which the last party signed the agreement, 18 July 2022. Now, it is apparent from the record that Mr. Namanje stated that the fourth applicant cannot testify as a fact that there was an effective date because his clients testified that the agreement did not have an effective date. The court, alive to the evidence, informed Mr. Namanje that that was indeed his client's evidence. However, it appeared that the fourth applicant's evidence was to the contrary. In amplification, the fourth applicant relied on clause 1.3 of the APA, and this effectively settled the issue of the effective date, being 18 July 2022. Therefore, the evidence of the first and second applicants that the APA had no effective date was a blatant lie. Further, the first and second applicant were also not truthful when they testified that Namcor Trading did not acquire ownership because they, in bracket, first and second applicants, learned that they cancelled the agreement. Firstly, the effective date for delivery of the assets was 18 July 2022. And secondly, the first and second applicants could not have learned that Namcor Trading cancelled the agreement until 13th September 2020. Data, in other words, for a year, in other year, Enecon could not deliver to it cannot be due to Namcor Trading cancelling the agreement. Therefore, the above confirms the evidence of the investigating officer that Enecon did not sell anything to Namcor Trading to this day. In fact, the letter dated 13 September 2023 was addressed to Malema because the first and second applicants were no longer directors of Enecon at the time. The first applicant testified that he left Enecon on 21 February 2023, about 7 to 8 months after signing the APA and without delivery of the assets. It is apparent that the first and second applicants also testified that they did not prevent Namcor Trading from taking ownership of the assets. Once they concede that they did not deliver, the issue that they did not prevent them becomes immaterial. Therefore, the expression that Enecon sold dreams to Namcor Trading holds true because after the sale, Enecon took the money and still had possession or ownership of the assets to this date. Further, both the second and third applicants testified that Onyeka CC received an amount of 3.8 million. The second applicant testified that there was an agreement between Onyeka CC and Enecon for clearing, forwarding, and storage of goods because Onyeka CC is situated at number 15 Pasteur Street, a sectional title. They do not have space. Onyeka was having space to store all their goods, and equipment for fuel management technology, and that is why they received the money. Firstly, the above is very confusing because the second applicant stated that Onyeka Sisi was a sectional title at number 15 Pasteur Street without space. At the same time, Onyeka Sisi had space to store goods and equipment for fuel management technology. The first applicant testified that he was only a signatory to Onyeka bank account, and he could not remember why the amount was paid because it was a long time ago. However, it is apparent that this money was immediately paid to both the first and second applicants' personal bank accounts by Onyeka Sisi with reference management fee. It is not in dispute that each of them received 1.5 million from Onyeka Sisi. Further, the evidence of the first applicant that they would give the Ministry of Finance instructions with correspondency for them to deposit in a particular account confirms the investigating officer's evidence that payment can only be made to the account as provided by the service provider after verification. During cross-examination by Mrs. Hinda on record on behalf of the respondent, the second applicant testified that he does not have any relationship with the fourth applicant apart from Enecon and Namcor Trading. Subsequently, he testified that he knows the fourth applicant as the date on which the fifth applicant became a signatory to the bank account number 520. The first applicant conceded that he could not dispute that the fifth applicant was a signatory to the said bank account prior to 18 July 2022, the date on which the APA was signed. On the other hand, the second applicant testified that the signatories to the above-mentioned account were himself, first and fifth applicant, and he did not know any law that prohibited making such an agreement. The investigating officer testified that the fifth applicant became a signatory on 26 October 2021 before the FSA was concluded, which is in line with the evidence of the first and second applicant. To the contrary, the fifth applicant disputed the same. It is apparent that the fifth applicant testified in chief that the bank account number 520 was opened in October 2021 and her effective date as signatory was 16 March 2022 when the FSA was concluded. The Enecon Board resolution dated 26 October 2021 resolved that she should be added as signatory to the said bank account. However, on Namcor's side, her effective date was 16 March 2022. As stated above, both the first and second applicant testified that she was a signatory in October 2021, even though they could not recall the exact date. During cross-examination, it was put to her by Mr. Lilungwe that the investigating officer will testify that she had access already in October 2021. She testified that the account was opened in October 2021, but Namcor Trading only gave her authority on 16 March 2022. Before that, she was not authorized. She proceeded that even though she had access to the account, her authority only started when the agreement was signed. Pressed further on whose instruction was she acting when she had access, she testified under the authority of the FSA duly signed by the fourth applicant. It is apparent that she was adamant that she did not have access or signatory rights until 16 March 2022. Therefore, a concession means that she was not truthful in her evidence in chief. Further, the problem is compounded by the fact that at the time, 26 October 2021, there was no FSA between Enecon and Namcor Trading. As such, her authority could not be derived from the same. Such was only signed on 16 March 2022. Further, her concession during cross-examination confirms the evidence of the investigating officer that she had authority or signatory rights to the said account in October 2021. In fact, the fifth applicant signed the Enecon board resolution at the bank on 1 October 2021, so that she could be the joint bank account. Further, during cross-examination by Mr. Lilongwe, she testified as follows. There was a board resolution for Enecom which I signed when the account was opened. Did I have access? Yes, I had access, but I am not an employee of Enecon. Therefore, the fifth applicant's evidence to the contrary was a blatant lie. Further, the fifth applicant testified that there was a session between Namcor Trading, Enecon, and Eco Fuel CC, which is not correct. Further, the evidence of the investigating officer that the invoice was sent directly to her on 19 July 2022 at about 0917 was also not challenged. Further, the record reflects that during cross-examination by Mr. Lilongwe, the fourth applicant testified that Namcor is 100% owned by the government. Namcor Trading does not receive money from government. It is apparent that the respondent's version is that Namcor and Namcor Trading are one and the same institution without separate legal personality, whereas the fourth, fifth, and sixth applicants specifically argued to the contrary that they were two separate legal entities. In other words, the issue was that Namcor Trading is not a public institution, not, in brackets, not designated as a public enterprise under PEGA. It was put by the fourth applicant, receiving public funds, whereas Namcor Trading is a private entity, 100% owned by Namcor, not by government, as stated at paragraph 74 above. With regard to the issue of a commercial transaction, this court is of the considered view that the issue whether Namcor Trading is a public institution, public officials or not, goes to the heart of some of the applicant's defense and thus to the merits of the case. Firstly, it may or may not be a public institution, and the applicants, as aforesaid, may or may not be public officials. Secondly, it may or may not be receiving public funds. The veracity of the totality of the evidence would not ordinarily beg consideration at this stage of the proceedings. Accordingly, it's an issue to be decided at the trial. It is also apparent that the fourth applicant testified that approval above 25 million required board approval. The APA was above the threshold of 25 million. During cross-examination by Mr. Casper, he denounced that Namcor bought dreams. However, as stated above, it is apparent that Namcor Trading did not get ownership or possession of the assets, contrary to his evidence that they did. Further, the fourth applicant testified that clause 1.1 at page 53 states that before the effective date, NECON shall deliver to Namcor Trading all certificates, ownership documents, registration documents, assets, maintenance records, asset registers as signed by the auditors, warranties, if any, or any other documents necessary to ensure transfer of the ownership of the assets to Namcor Trading was complied with. However, he proceeded that obviously he did not work with those things directly himself, but he could see the asset register, and he was told that that was the proof of ownership required before he could proceed. Suffice to state that it is apparent from the record that the second applicant further during examination of the it is apparent that NECON had the required certificate to operate tanks. It is not borne by the record whether Namcor Trading had such required certificate. Further, during cross-examination by Mr. Lilungwe, the fourth applicant conceded that he needed board approval for purchases above 25 million. He testified further that there was board approval for the purchase of the assets in 2022-2023 financial year. On a follow-up question whether he had proof that the purchase of the assets was approved by the board, he testified that the FSA based the APA as such, it was not deemed to be a new procurement, but they had to implement the agreement and it was budgeted for in the current budget. The fourth applicant proceeded to testify that the board does not approve every specific transaction or asset purchase because it is in the purview of management. However, what the board needs to approve is a budget relocation and things like that. It is apparent that he disputed that the agreement was cancelled because there was no board approval. Further, it was put to him that he disregarded that obviously when they carry out this sort of transaction, they try to make sure that they do according to the schedule of authority. But it looks like there might have been an oversight. He proceeded that, I mean, nobody is perfect. We all make mistakes. The issue is that we were supposed to go back to the Finance and Audit Committee to actually get approval to reallocate the entire budget from one budget. Therefore, even though he was adamant that there was board approval, he subsequently conceded that there was no board approval due to oversight. The fourth applicant testified in chief that he got to know Malema because he became one of the clients of Namcor at the time and denied ownership, possession, or being offered the said vehicle. The investigating officer testified that he personally saw the fourth applicant using, in brackets, driving it. During cross-examination by Mr. Lilungwe, the fourth applicant testified that he knows Malema, but he had a business and not personal relationship with him. Further, he conceded that he took the vehicle in question for service because he drove it for 2 or 3 days. Malema asked him to drop it on his behalf as he was flying to Ondango. Put to him by Mr. Lilungwe under cross-examination that the investigating officer will testify that he drove it for more than 3 months. He testified that he did not say that he only drove it for 3 days, but a couple of days. Further, he testified during cross got acquainted that they were doing business at Namcor. He in fact drove it the first time when it arrived, as he took it for a test drive. In her evidence in chief, the fifth applicant testified that accused 2 was a member of the credit committee. However, during cross-examination by Mr. Lilongwe, she testified to the contrary, that accused 2 was not a member of the credit committee. On a follow-up question, she was referred to Exhibit E2, page 306, dealing with the composition of the credit committee, and subsequently she conceded that accused 2 was a member of the credit committee. In other words, not only did she concede that accused 2 was a member of the credit committee, but also that Mr. Lilongwe was correct that he was a member of the credit committee. Now, such contradictions did not go unnoticed. Further, the fifth applicant testified in chief that the fourth applicant's authorization had no limit, but she also conceded that to acquire the assets in excess of 25 million, there was need for board approval. The fourth applicant conceded during cross-examination by Mr. Lilongwe that his authorization was limited to 25 million in terms of the schedule of authority, and anything above that required board authority. Board approval. There was an oversight because the board needed to approve the reallocation. When the fifth applicant was asked, was it approved by the board? She testified, no. If a budget is approved by the board, you don't go back to the board and ask for approval again. The board gave the approval to spend during the financial year. The board was not responsible for operational matters but strategic. In other words, her evidence was initially that the board had approved the budget, so there was no need for board approval again. However, subsequently, she considered that there was no board approval. Further, the fifth applicant testified during cross-examination by Mr. Lilongwe that she could not recall that the credit guarantee for Enecon was removed on 29 November 2021. She testified that she was not aware about the concept zeroized. It is apparent that the investigating officer's evidence that Enecon provided a credit guarantee of 5 million Namibian dollar and the same was removed by the fifth applicant on 29 November 2021 was not challenged. As stated above, the sixth and seventh applicants brought their bail applications by way of affidavits. It is common cause that the 6 applicants dollars paid into a personal account by Venus Technology CC through Irongo Petroleum CC on 4 August 2022. However, she claims that such payment was made in respect of consultations she did in relation to feasibility study for an intended medical center. The investigating officer testified that an amount of 1 million Namibian dollars was paid by Irongo, by Eco Trading CC to Venus Technology CC on 20 July 2022, and part of that money initially originated from Namcor Trading. It is part of that money that was paid to the 6th applicant on 4 August 2022. It appears to court that this aspect was never challenged. Mr. Casper, on record for the 6th applicant, stated that his client denies receiving gratification and she did not know where the money came from, and that the evidence will be tested at trial. The investigating officer testified that it is proceeds from Namcor. Suffice to state that once she confirms receipt of the said money, the rest is for the trial court. in paragraph 33 of her affidavit, the 6 applicants stated that only a bank statement of Venus Technology CC was disclosed to her. Further, she proceeded that she was unable to engage with sufficient details thereof. It is ironic that she can do no better than inform the court that she is not guilty because she has not received disclosure. Put differently, she is unable to refute the allegations leveled against her. She elected to bring her bail application on affidavit, which has disadvantages and disadvantages. Further, before the court is tested viva voce evidence, which carries more weight, more probative weight than an affidavit. The 6 applicants stated in her affidavit that she had no authority to increase credit limit as alleged. Without going into the merits, it's apparent from the evidence of the 4th and 5th applicant that she was a member of the credit committee responsible, among others, to approve credit requests to customers. It is also common cause that she prepared the internal memo dated 8 July 2022 for approval of the APA. The investigating officer testified that the evidence shows that there was conspiracy between Enecon and in bracket the first and second applicants who accepted and signed the offer, as well as the 4th, 5th, and 6th applicants, as well as accused 2. Conspiracy was disputed. Suffice to state that this issue goes to the merits and does not bear consideration at this stage of the proceeding. It was put to the investigating officer by Mr. Casper that her client only received 10,000 Namibian dollars, a drop in the ocean, to which she testified that it might look insignificant, but it is her conduct that matters. Now the seventh applicant stated in his affidavit as follows, paragraph 36, at registration of Irongo Petroleum on 13th February 2022, the membership interests were as follows. 36.1, Mrs. Saima Emmanuel held 40%. 36.2, Mr. Emmanuel Panduleni Iyambo held 20%, and 36.3, Mr. Leon Nandango Stefanas held 40%. Paragraph 37, on 20, he stated that on 23 November 2020, the amended founding statement of Irongo Petroleum indicates that membership interest as follows. Leo Nandango Stefanos, 70%. Matthias Pandukeni Iyambo, 15%. Christina Kambondin Dafenongo, 15%. Paragraph 38. On 14 May 2022, a further amended statement reflects that he held 100% members' interest. Another amended founding statement at paragraph 39 reflects that he held 100% members' interest with effect from 27 with an effective date of change of 27 October 2023. A further amended founding affidavit founding statement reflects that Austin held 75% members' interest and the 7th applicant 30% members' interest, effective 13 November 2023. Now, it is apparent from the above that, that on registration of Irongo Petroleum, in brackets Irongo Petroleum CC, on 13 February 2020, the 7th applicant had 40% members' interest until 23 November 2023, when his membership interest changed to 7. On 4 May 2022, his membership interest changed to 100%. He held 100% members' interest until 13 November 2023, when it changed, with Austin holding 75% and him 30% as per his affidavit. It is common sense that percentage is over 100. The above percentages, 75 and 30%, goes to 108%, which is not correct, but that is how it appears in his affidavit. During cross-examination of the investigating officer, it was put to him by Mrs. Gebhardt on record for the seventh applicant that the other member ceased membership on 27 October 2023 in terms of paragraph 43 of her client's affidavit. Further, it was submitted by Mrs. Gebhardt that the investigated founding statement for May 2020 and disregarded the amended founding statement of October 2023. The investigating officer correctly testified that on 14 May 2022, the amended founding statement indicates that the seventh applicant held 100% members' interest until 13 May 2023, when Austin held 75% and him 25% members' interest. It is also apparent that the total percentage as reflected by the investigating officer is 100%. That is 75% and 25%, which is correct, as opposed to that of 105% in the seventh applicant's affidavit. The version put by Mrs. Gebhardt to the investigating officer and her submissions on behalf of the client were contrary to her client's affidavit and palpably false. As stated above, paragraph 38 and 39 of the seventh applicant clearly indicates that he held 100% interest from 14 May 2022 until 13 November 2023, from which date Austin held 75% and him 30%. Iyambo and the Fanango ceased to be members on 14 May 2022 when he became 100% members' interest, not 27 October 2023, as it was put to the investigation examination. So that the accused, in bracket, applicant is bound by the conduct of his or her counsel of record. Therefore, this court finds that Mrs. Gebhardt's version and submissions on behalf of her applicant was not only aimed at misleading the investigating officer, but the further paragraph 44 of the seventh applicant's affidavit and 2023, the members were himself, Matthew Panduleni, Iyambo, and Christina Kambondi. The Fanango is contrary to paragraph 38, which clearly states that on 14 May 2022, he held 100% interest. It is for these reasons that the court declined Mrs. Gebhardt's invitation, as stated at paragraph 66 above, to make an extempore judgment and grant her client bail if so inclined. Therefore, the investigating officer correctly stood his ground, and Mrs. Gebhardt's version and submissions were misleading. As stated above, payments are not in dispute, and same is apparent from Ms. Gebhardt's cross-examination of the investigating officer. It is not in dispute that Irongo Petroleum paid 500,000 to Quality Meat CC, which was subsequently paid to Panduleni CC. Further, it is tried law that bail on affidavit is permissible in our law. However, an affidavit carries less probative weight than viva voce evidence which has been subjected to the test of cross-examination. In Esau versus the state, the court cited with approval the decision in Josiah Boyce versus the state at paragraph 28, where it was stated as follows. As alluded to earlier on, the applicant declined to go into the merits of the charges he faces, which he is entitled to, on the basis that he would only deal with same at the trial. That being the case, the respondent's version on the strength of his case against the applicant remains uncontradicted. In Gipunya versus the state, it was stated as follows. When the defense decide for whatever reason not to cooperate and disclose their defense information which is needed by the court for purposes of adjudicating on the bail application is not available, if that information is favorable to the applicant, it stands to reason that the defense is at all risk to prejudice the accused at the bail hearing by withholding such information. It furthermore, the aim is to gain time to concoct a false defense, then the blame for such detention of the accused without bail lies squarely on the shoulders of the defense. It is tried law that the applicant bears the honors of proof and on a balance of probabilities, and depending on the circumstances of the particular case, it may require the applicant to address the merits in all allegations. Further, it is also apparent from the evidence above that the applicants, except the 6 applicants, were not truthful before court in material respect. The evidence was replete with material contradictions and falsehood, both in evidence in chief and cross-examination. The 7th applicant clearly misled the court. In Muladi versus the state, it was held that the analysis of the evidence showed that the appellant was not honest when he informed the court about his place of residence, held further that the court drew an adverse inference from the conduct of the appellant where he led the court in relation to his place of residence. The court found that the appellant did not take the court into confidence in his evidence pertaining to his place of residence, and accordingly the appeal was refused. The same applies in S versus Matali, where it was held that the appellant's application contained contradictions and anomalies that came out during cross-examination, and various contradictions and anomalies were stated. The appeal similarly was refused. Further, it was submitted by Mr. Bangamwaba on record for the 4th and 5th applicant that the investigating officer's evidence was replete with material contradictions, and his evidence should be regarded. It was argued that he specifically testified in chief that he never met the 4th applicant until he was arrested. But during cross-examination, he testified that him and his colleague followed him during investigation. Further, it was put to him that the colleague was dealing with the first and second applicant, and he told them that he had no objection if bail is granted to the 4th applicant, if bail is if the bail is granted to the fourth applicant? Would he have a problem if he reports to him at the ACC? He responded that he was firstly opposing bail, and so in the event that the court decide, he was not to determine the conditions. A follow-up question was put to him that he testified through cross-examination by Mr. Namanje that he would accept the report to the ACC or to the police officer, and he responded that no comment. It was then stated that he had retracted himself. It is apparent that retraction is not permissible. However, it is apparent from the evidence on the record that the investigating officer testified that he never met the fourth applicant until he arrested. However, it was further his evidence that he followed him. It's apparent that there's a difference between meeting someone and seeing someone. Therefore, for that being said, this court does not find merit in the said submissions. Now, on the charges preferred against the applicants, there was a heavy onslaught on the charges preferred against the applicant. It was submitted by counsels on behalf of the applicants that the charges were weak, half-cooked, chaotic, pathetic, nonsense, and state case was bleeding. Mr. Nilungwe contended that this was a bail application, not a trial. The applicants were aware of the charges, and bail proceedings cannot be used as a backdoor to challenge arrest. It was specifically submitted by Mr. Namanje that the applicants were not challenging the validity of their arrest, but whether the arrest was necessary is a necessary consideration in a bail application, and reliance was placed on the cases of Hailulu, General Hamunyela, and Unengu case. As stated above, this court is only concerned with the bail application. And the issue is whether the candidates or the applicants are worthy being granted bail. It's right that the applicants for bail must specifically make out a case and not necessarily rely on the perceived strengths or weaknesses of the state's case. See in this case, S versus Ngepunya. It is apparent from the record that during cross-examination of the investigator, Mr. Namanje stated that count 39 and its affidavit, the state correctly elected to charge his clients 132 in bracket 5, whereas count 34 to 38 and 40, the state did not rely on section 332 in bracket 5. The gist of it is that most of the charges did not state that the applicants that the applicants were in 32 in bracket 5. The officer considered that some of the charges did not state section 332 in bracket 5. However, he testified that the applicants have not been asked to plead, and the state can amend the charges. The applicants are charged personally and in their capacity as directors or members of the entities. The state has a strong case. Ms. Gebhardt is on record that they know that the applicants are, that these are not the charges the applicant will plead to in terms of section 119 or at trial. However, they were dealing with the charges as is. It is also apparent that Mr. Namanje, during cross-examination of the investigating officer, stated that it was common cause that 2.5 million came from Namcor, not from the first and second applicants personally. Further, the record reflects that the first applicant in chief testified that count 35 and 36, he does not know why the state did not choose section A or B. Count 40, count 40 was directed at him personally, and section 332.5 is not mentioned. Subsequently, he testified on count 40 that it was correct. The agreement was between Enecon and Namcor, trading and no dispute. He proceeded that count 40, A and B was correct. The second applicant testified that count 43, that Enecon sold rights, title, and interest to Namcor for 43 million, not him personally. On count 44, he did not offer them. He did not offer them and did not know that second, fifth, and sixth applicants abused their office. On count 45, he personally never sold to Namcor but Enecon. On count 48, he testified that the dates are different. October 2021 and 15 July 2021. It appears that those are issues of technicalities which were raised, but some of the charges, not all the charges are faulty. Some of the charges, as indicated, have been correctly spelled out. And as indicated further, that the charges, the applicants know the charges they are facing. They were not prejudiced in their bail application. Therefore, this court does not find merits in such submissions. Further, in Charlotte Helena Botha, it was stated that in order to successfully challenge the merits of such a case in bail proceeding, an applicant needs to go further. He must prove on a balance of probabilities that he will be acquitted on the charge. For purposes of bail application, the applicants know and understood the charges preferred against him and were not prejudiced. In fact, some of the applicants testified that they did not personally enter into a contract with Namcor Trading or receive money personally, but their business entities or associates thereof. Further, the case, Unengu case referred to above, cited. Unlike in the present case, in Unengu case, the state did not lay out the allegations against the appellant on the record as to what exactly he was alleged to have done. Therefore, the Unengu case is distinguishable from the present case. The charge sheet that was on record on appeal was prepared after the bail application for purposes of section 119 proceeding. It is also apparent that the court acquired in that case was in the dark about the allegations, the dates, the place, and the time during the bail application. That is not the position in the present case, even though some charges may be wanting one way or the other. It is common cause that both Hailulu and General Hamunyela cases are civil matters in the High Court of Namibia, and thus distinguishable from the present. In Hailulu case, the appellant brought an application to review, among others, the ACC's decision to investigate him and set aside his arrest and detention, as well as bail conditions. It was held on review that to set aside the investigation and subsequent prosecutions was not competent, whereas his arrest and detention was declared null and void. Similarly, in General Hamunyela case, the applicant challenged his arrest and subsequent detention, and same was declared unlawful. Suffice to state that the applicants in Kasu are not attacking their arrest and detention. The magistrate's court is a creature of statute and not competent to entertain such issues, even if they were attacking their arrest and detention. Therefore, nothing turned thereon. In the case of Amshelelo, reliance was placed on that case, arguing that the other applicants were granted bail. Now, it is apparent that the investigating officer testified that they have considered the role each accused played in the matter, and with regards to the third applicant, with regard to the third applicant, regarding accused 10, the present bail application when accused 10 was granted bail, and he was not at liberty to divulge such information. Mr. Lilongwe on the record stated that they applied their mind to the facts and considered the evidence on the record. Therefore, it appears to this court that the state applied its mind, and that is apparent on the record in respect of the third applicant. However, the court is unaware why accused 10 was granted bail. Be that as it may, each case is decided on its own merit. Further, there was also an issue regarding the seizure of the applicant's cell phones. The law permits that under certain conditions, seizure of properties may be allowed. And it was argued that that was done in violation of the accused's rights. Suffice to state that the admissibility of such evidence so obtained will be determined at the trial court. Nothing turns thereon. Now, with regard to the grounds of objections, generally the applicants testified and stated in their affidavits that they will not abscond. They want to stand trial and clear their names and have no intention to run away. It is common cause that the first, seventh, and sixth applicants personally reported to the ACC officers and police stations and subsequently were arrested. The fifth applicant went with his lawyer, the sixth applicant reported to the Windhoek police station, and the seventh applicant reported to the ACC. The second applicant testified that he was in the north about 60 kilometers to the Angolan border, and he could have ran away if he wanted. However, he chose to come even though he already knew through the grapevine about the imminent arrest. The fourth and fifth applicant testified that they were already aware about the investigations and decided to stand trial so that they can clear their name. Therefore, on the record, it is not apparent, there is no evidence that the applicants will abscond. Interference with investigations or witnesses. It was further appellants testified that they are testified and stated in their affidavit that they will not interfere with witnesses or investigation. They are unaware of the identity of investigations or witnesses. As such, they will not interfere with them. It was the investigating officer's evidence that the risk is there, and he believed that they will interfere with investigations because they did not know then that they were going to be arrested. But now that they've been arrested, he believed that they will interfere. Now, the test with regard to interference with investigation is whether there is real likelihood that the applicant will not may interfere. It is apparent that the investigating officer testified that the applicants are branches of the same tree due to the relationship and that the business entities are registered in. However, also apparent from the record that the applicants have not personally interfered or attempted to do so. Therefore, this court finds on the evidence that there is a very remote possibility that the applicants may interfere with investigations or witnessing. With regard to the seriousness and strength of the state's case, it is apparent that it was contended by the applicants through their counsels of record that the state's case is weak, pathetic, and chaotic, as stated above. They argued it was a commercial transaction, not a transaction. The court will not deal with the issue of commercial transaction as it has already been stated above. Neither will the court deal with the issue that the applicant, that Namcor Trading was not a public entity but a private entity, as that issue has been already dealt with. The investigating officer testified that the charges are serious. They involve fraud, a Schedule 2 offense, money laundering, and contravention of various sections of the ACC Act. The 6 applicants stated at paragraph 32 of her affidavit that she does not dispute that all or most of the charges are serious in nature. The second applicant testified that corruption is serious in nature, but the public needs to know the truth and correct facts. Therefore, in this, there is no doubt that the charges preferred against the applicant are serious. Further, the charges herein are economic in nature and involve a significant amount of about 400 million. With regard to public interest or interest of the administration of justice, the applicants argued that it was in the public interest that they should be granted bail. The state case was not strong but just fueled by the media. The truth and the facts were not correct as published by the media. To the contrary, the investigating officer testified with regard to the issue of public interest and interest of the administration of justice that the offenses are serious. The public was concerned and the offenses are of economic nature, which has significant impact on the economy. It was submitted on behalf of the state that it was not, it was submitted on behalf of the state that it was not in the public interest or in the administration of justice that the applicants be granted bail. In the matter of Lazarus Shaduka versus the state, it was stated as follows at paragraph 27. Where an accused person has been charged with the commission of a serious offense and if convicted, a substantial sentence of imprisonment will in all probability be imposed. That fact alone would be sufficient to permit a magistrate to form the opinion that, that it would not be in the public interest or interest of the administration of justice that the applicant be granted bail. In Gepunya versus the state, at paragraph 44, it was as follows. The days of distinguishing between the seriousness of monetary crimes and violent crimes can no longer be seen to be different in bail applications. Whether the crimes involve public funds or a physical attack on a member of the society, if the circumstances permit, the seriousness of the offense thereof must be taken into account when considering bail. In this matter, the misappropriation of public funds affects every individual of the Namibian public and needs to be seen for the detectable crime it is. These, together with factors outlined above, are essentially enough to ensure to arouse a court to view that the administration of justice does not merit the release of the applicants on bail under the circumstances. In Esau versus the state, it was stated as follows at paragraph 101. In this case, it is a notorious fact that enjoys huge public attention before and after the arrest of the accused. The matter is widely and extensively reported on by the media. This is not necessarily decisive that the public has an interest in the matter, because the public might have certain expectations which are not synonymous with public interest. It remains, however, a factor to be considered. In this matter, it needs consideration together with the relevant factors that the applicant, one, and some other co-accused held positions in public offices. In addition, the serious charges where huge amounts of public money should have been availed for public benefits and involved. Instead, it is alleged to have been laundered and squandered for the benefit of a few. The evidence alleged that several millions of taxpayers' money is involved, on which there was allegedly tax evasion. That was stated in the case of Esau versus State. As stated above, the applicant faces charges, among others, fraud and conspiracy, which offenses fall under Section 4, Schedule 2 of the CPA. Therefore, Section 61 finds application. This matter, enjoys huge public interest and was widely and extensively reported by the media during the arrest of the accused, in brackets applicant, and throughout these bail proceedings, both in the print and electronic media as well as social media, to the extent that the entire bail proceedings was broadcast live on national television to this date. This does not necessarily mean that the public has an interest in this matter, but may have expectation not necessarily synonymous to public interest. However, it is a factor to be considered together with other factors. The allegations against the applicants involve serious charges where substantial amounts of money were paid to various business entities in which some of the applicants and their associates have an interest, as well as some of the applicants and accused persons in their personal bank accounts. The manner and the speed in which the funds were paid from Namcor Trading to the various business entities, some of the accused persons and applicants, is another issue of concern. It is apparent that some of the accused and applicants were employees of Namcor and Namcor Trading at the time. Further, the court is alive to the fact that a suspect, Malema, has fled the country and the vehicle in question has not been traced. Therefore, taking into consideration the totality of the evidence, even if there is a remote possibility that the applicants will interfere with witnesses or investigation and abscond, it is this court's considered view that it is not in the public interest or interest of the administration of justice that the applicant. Conclusion, it is apparent from the evidence of the applicants, to the exception of the 6 applicants, that they contradicted themselves in material respects, both in their evidence in chief and cross-examination, as well as on affidavit and submissions in respect of the 7th applicant. Their evidence was riddled with material contradictions and falsehood. Further, it is also apparent that the applicants also made material concessions on the record, which to some extent confirms the state position. Considering the totality of the evidence, it is this court's considered view that the applicants failed to discharge honors of proof on a balance of probabilities that they are good candidates for bail. The question of bail conditions only becomes relevant once the court finds that the applicants are good candidates for bail. Therefore, notwithstanding that there is a remote possibility that the applicants will abscond or interfere with state witnesses or police investigations, this court is of the considered view that it's not in the public interest or interest of the administration of justice that the applicants be granted bail. In the result, the following is the order of the court. The applicants, that is first, second, fourth, fifth, sixth, and seventh applicants' application for bail is refused. The applicants are to remain in custody. The matter is considered finalized and removed from the roll. What is the date? The judgment is available. The court will provide each of the counsels with the copy of the judgment.
Worship, I did not diarize it in my diary, but I think the date should be on record, the next postponement date. I apologize for that.
Boss counsels. I'm going to give you the record because I see that the postponements are for.
Yes.
The other postponement must be. There must be a date for investigations also.
Can just bear with me. I know it was in court on the 31st of July. May I just request a short
The court will then briefly adjourn.
First.